My lord, I beg to mention item number 29 and 30, my lord. With the consent, my lord, with the consent of the petitioner, my lord, we need 3 weeks time to file our affidavit in opposition on behalf of FCI respondent. It has been prepared, waiting for vetting, my lord.
Mr. Singh, learned standing counsel,
Your Lord,
Yeah.
for the petitioner.
submits that the affidavit on behalf of the respondents represented by him is being prepared and would be filed within a period of 2 weeks from today.
My lord.
2 weeks from today. Accordingly, he prays that the matter be adjourned for further 2 weeks. Also, prayer is not objected to by the learned counsel for the petitioner. Also, accordingly, registry to list this matter after 4 weeks. The respondents shall bring on record their affidavit by within a period of 2 weeks from today, and thereafter the petition shall be at liberty to file its rejoinder, ipso advised within a further period of 2 weeks. Also,
My lord, in item number 13, names are not being shown on behalf of FCI, my lord.
Item number 30.
30.
Okay.
FCI.
To list this matter after 4 weeks, showing, reflecting the name of SA apostrophe QDB, FCI apostrophe over in the cost list. Yes.
Much of
Obliged, my lord.
Lordship, in item number 40, we have filed an affidavit. Lordship may kindly call it on the record. Obliged.
Your Lordship, it is a pending matter. The railway respondent is going to evict the petition on 30th.
I'm sorry, this is not the senior bench. You will have to mention the senior bench of Asani Moinigi. Papa Moinigi. Yes.
These are the 2 cases which is pending before this court, Your Lordship.
Oh,
They are going to evict on 30th. Kindly fix on 27th, Your Lordship, for the hearing. Earlier it was fixed on 25th March.
yes. Have you not, as the estate officer passed his orders?
Your Lordship, no. They have informed. There is no order of black and white, Your Lordship. It is not in black and white. They have
Is there any interim order passed by this court?
No.
Affidavits not filed.
Counter
Filed.
has not been filed by the railway till date, Your Lordship.
Okay, let's.
Yes.
Lordship, in item 27, Lordship, we are supposed to file our reply on 28th, but because of my health issues, I could not file, Lordship.
On the prayer of Mr. D. Das,
1 week, Lordship.
learned counsel for the petitioner. Further, 1 week time is granted to bring on record a rejoinder to the affidavit file. Rejoinder on behalf of the petitioner to the affidavit filed by the respondents. Registry to list this matter after a week.
I'm obliged.
Wait, please, Lordship. I beg to mention Section 45, Lordship. The matter has become infructuous. Item 45, Lordship.
Miss
Bidas on behalf of A.M. Ahmed. Your
Ms. B. Das, learned counsel, appearing on behalf of Mr. On instructions, appearing on instructions from Mr. A.M. Ahmed, learned counsel for the petitioner, submits that the issue involved in the present writ petition, during the pendency of the same, has been rendered infructuous. Accordingly, she prays that the writ petition be closed as having become infructuous. Prayer accepted. The present writ petition stands closed as having become infructuous.
And Lordship, item number 46, Lordship, may adjourn the matter for the day, Lordship.
46, which is the one you want to withdraw?
45, I want to...
Means non-infructuous, 45 day.
And 46, I want to adjourn my Lordship.
On the prayer of the learned counsel for the petitioner, registry to list this matter after 2 weeks on a date to be fixed by.
Lordship.
Yes.
Lordship, I beg to mention item number 43, Lordship. In this case, petitioner has died and I need to implead the party, but there is no instruction from the petitioner side, Lordship.
We'll adjourn it. Mr. A.K. Sharma, learned counsel for the petitioner, submits that he be permitted, submits that the matter be adjourned for further 3 weeks so as to take steps for substitution of the petitioner, who has passed on, during the pendency of the present proceedings. Prayer accepted, registry to list this matter after 3 weeks on a date to be fixed by
Please, Your Lordship. So back to mention item number 41.
Huh?
41, Lordship. Matter may kindly be adjourned for the day, Lordship.
You are for the petitioner.
For the petitioner, Lordship.
Okay, for the petitioner. Your name?
A. Ahmed appearing on behalf of Mr. R.
Learned counsel for the petitioner. Matter stands adjourned for a week. Huh?
Obliged, ma'am.
May it please your lordship. Lordship, with the consent of the other side, I beg to mention item number 32, your lordship. Lordship, we were to file our affidavit in opposition. Lordship, it's been sent for vetting. Lordship, we'll file it within 2 weeks. Your lordship.
Learned standing counsel, ECI, submits that she be granted for the 2 weeks time to bring on record a stand. Bring on record the stand of the respondents represented by her by way of filing an affidavit. Have you informed the
Lordship, I've taken consent.
there is, no objection has been raised by the learned counsel for the petitioners. So accordingly, registry to list this matter again after 2 weeks question or 3 weeks question. After 2 weeks on a day. 2 weeks will do?
2 weeks. Highly urged.
Meet please, Lordship.
Yes.
Lordship, I beg to mention for listing of writ petition, Lordship.
Bench 4.
Pence for Lordship.
Why to bench 4?
Lordship.
Give it to.
Obliged.
Item number 1 and 2. Unfortunately, I was not here. The file was not gone with me. I'll pass the orders at 2 p.m.
At 2 p.m.
2 p.m.
Hello.
Item number? The NIT copy has not been brought from that one.
We have applied we have filed an RT application to.
Why you don't have that copy with you?
Yes, Lordship.
You submitted a bid, you don't have a copy.
As of now, I don't.
Only
have
thing is that from that only we can know the area and all things.
That's the Lordship.
Okay.
I'm taking time today, Lordship, for a week, Lordship.
Miss M. Nirola, learned counsel appearing for the petition, submits that she be granted 1 week will do or 2 weeks.
Week, Lordship.
Submits that she be granted a week's time to bring on record, to file an additional affidavit to bring on record the notice inviting tender, basing on which the settlement in question was made with the petitioner. So prayer accepted, registry to list this matter again after a week.
Obliged, Lordship.
It's down to online. Page 3 order to person, it is order to pass question.
Mr. A, senior advocate, Mr. A is just supposed to.
Yes, Mr. Das, are you online?
पर ऐसे नहीं है down to एकदम आना है चलिए ऐसे नहीं 3 चलिए से 3 चलिए ना
This is also some entertainment.
20 to join है
Maybe after some time.
You inform me.
Yes.
Now, Mr. Bhattakur,
This is where the location has been dropped.
drop from? That you are not opening anything there.
Yes.
No, you say because no eligible candidate is there. But if we hold that he is eligible, then
But he is not eligible.
oh,
Yes.
subject to that, we hold. So this is not a dropping only because that you don't want that area is not feasible. This is a dropping because there was no eligible candidate. Right? So we'll have to then still examine that issue. Okay, you inform me.
Yes.
Mr. Gogoi, I can't take up this matter. I had appeared for the petitioner around 4 matters, then writ appeal just before my election. Matlabuddin Ahmed is one of the directors.
Lordship.
Registry to list this matter before any other bench without me. As urgency has been expressed by the learned counsel for the petitioner, registry to list this matter again on Wednesday before the appropriate bench.
Lordship. Obliged.
Lordship made cases, my lord. Herein, my lord,
Have you got the amount?
no, yesterday I talked to him.
Ah,
Okay.
the notional benefit has not been given. Yes, madam. Ms. Bora. Ms. Bora. We can see you, but your sound is not coming.
Lordship,
Ah.
am I audible, my lord?
Yes, very much. Any.
Lordship is not audible to me, my lord.
Oh.
Lordship,
Ah.
Lordship.
Am I audible now?
Lordship is not audible to me, Lordship.
Okay, you tell me what you have to tell. What is your instructions? Was the notional benefit, why the notional benefit was not given while regularizing his 4D appointment?
Lordship,
The retrospective effect was not given.
my lord is not audible to me. There is some technical problem, Lordship. Lordship, kindly fix the matter. Tomorrow I'll come to the honorable court.
Oh, no. Today itself. What is there?
I'm not.
Okay, you come back after some time. You connect back after some time. Reconnect again.
Lordship is not audible to me, my lord. There is some technical problem.
So, the only thing is, you were given a retrospective effect.
From the date of joining, not from the date.
No. From the date your junior was promoted.
Lordship, one order is passed by the department, my lord. Then I have emailed to my lordship email.
Okay.
On 18th of
My
5,
personal
department.
email
Yes.
or the court email?
Lordship, I'm not audible to my lord.
I said recorded, sir.
Kiba is in email.
Lordship, I
Okay.
have mailed one
Ms. Bhavan,
order.
we'll take it up after some time.
We
You
stuck up
please
in.
come back whenever you are free.
Yes.
We'll take after some time. Mr. Dotov.
Hello.
On the last occasion, I was with a view that it also tantamounts to a termination. Right, it tantamounts to a termination. But it is not a termination like dismissal or removal. Right?
It's a voluntary retirement.
No. This is compulsory retirement.
Sorry, compulsory.
And it's a penalty.
Right.
So, you have to give him something.
No, in compulsory retirement, they get some amount of pension.
But here there is nothing. That is the claim.
That he is eligible, my lord. But I think 2/3, I'll just.
2/3 minimum you'll have to give.
Right. Your lordship is very right. My lord, your lordship may.
So that much he is entitled.
Right. I was about to say that, my lord.
Rule 31. But these rules are of 2018. And his termination order is of?
My lord,
15.
that may be another thing, my lord.
What was the law when he was placed?
Well, in regard to that, my lord, possibly I'll have to get their instruction.
Because this I got it when I was going through. This 31 I got.
Yes.
But 31, whether it will have retrospective.
Whether it will have retrospective effect. My lord, possibly that instruction I'll have to take. I just missed that the lordship rightly said if he was, the punishment was in 2015.
Because you say in your affidavit that he is not entitled to anything.
That possibly, in view of that fact, possibly, my lord, because he was dismissed way back in 2015.
No, got it. You say that terminated. You have the regulation 2010 amended in 2000.
Yes. That I have.
Can I have 72?
72 millimeters. 72, my lord, I relied in regard to the gratuity. Your lordship may see E. 72 1E, my lord.
Okay, if you can come to the proviso.
Yes.
Now, provided that in respect of an employee, there shall be no forfeiture of gratuity. Provided that in respect of an employee, there shall be no forfeiture of gratuity for dismissal on account of misconduct, except in cases where such misconduct causes financial loss to the bank, and in that case, to that extent only.
My lord, this is a striking difference between these two. If he was an officer, my lord, in case of bipartite agreement, your lordship will
Oh,
find.
employee.
Yes, employee. So therefore, in regard to employee, this exception has been carved out because of the bipartite agreement between the management and the employees of the bank.
But because once you impose the penalty of compulsory retirement, you are not consciously forfeiting his past service, because then it would have been a penalty of dismissal or removal. But now, once you have applied the principle this of compulsory retirement,
Yes.
and your daughter does not say that this is the quantum of loss, then why will he not be entitled to all service benefits?
My lord, this part of the thing has been, my lord, already been concluded by this honorable court by a division bench judgment. Relying on, my lord, the parameter provision, the United Bank of India Officer Service
My
Regulation.
Lord Justice Ajit Singh's order.
Yes, yes. That is with your lordships also.
But here it is dismissal,
Dismissal.
not
Dismissal.
compulsory retirement.
My lord, if I read, my lord, gratuity, there is 72 1E. Termination of service in any other way except by your punishment after completion of 10 years of service. Now, if there is a disciplinary proceeding.
Now, what is termination? What do you mean by termination?
Termination of service in any other way.
Is it defined somewhere that the termination will also include compulsory retirement?
Obviously, my lord, because this is by your punishment. If it is by your punishment after completion of 10 years of service, then it will come.
That termination, Mr. This is a cessation. Understood. Cessation of service. But whether it can be taken to that level of a dismissal or a removal.
My lord, after all, my lord, after the disciplinary proceeding, if any punishment is imposed by you of compulsory retirement, this comes within the ambit of punishment. Because the wording is very clear, except by your punishment after completion of 10 years of service. So the phraseology is very clear, my lord. Except by your punishment, and then after completion of 10 years of service. He has completed more than 10 years of service.
And where are the penalties? 33 or 39?
39, your lordship will find.
Page 21, Lord.
This
Yes,
comes under
Mr. what do you have
major
to say?
penalties.
Lordship, as your lordship has rightly pointed out, the judgment which my senior counsel is referring is Read Appeal 59. This is with regard to the dismissal of the service. This cannot
No,
be a-
you show me that compulsory retirement will not be termination.
If your lordship see close,
And is he entitled to pension or only gratuity?
My lord,
pension and gratuity.
after 2018, the position is clear. They are entitled to get 2/3 of the pension also. But whether it is
Along with
having-
gratuity.
yes.
No, it's a pensionable service or only gratuity is paid?
No, I think it's pension.
Pensionable, sir.
Pensionable. service.
Pension.
Then at least he will have to have some amount of pension, forget gratuity.
Gratuity, of course, it is statutorily ousted.
Outstanding. So we accept that, but what about pension?
Well, the pension in regard to these, because this compulsory retirement was imposed way back in 2015. Now, the rule speaks it is with effect from 2018, whether they have given a retrospective effect or not. That is, my lord, what I need some instruction.
Yes.
This is from the date of publication in the official gazette.
There's a small area possibly, my lord, but
Yeah.
for the interest of justice.
Any decision?
Lordship, if my senior counsel is referring to this case in readable 59, I'd like to base the Shamlal judgment, Lordship. Because dismissal cannot be treated as a compulsory retirement. They cannot be the same. So like, if your Lordship takes to Rule 72, Lordship, try to just highlight. My senior counsel is referring to
Okay, what
72
does
clause E.
Ramlal say on that?
Paragraph 22 and 23, Lordship. Ramlal.
Which was the decision?
Can I just have a look?
I think the copy is here.
Ramlal is here.
Yes, Lordship.
Shyamlal.
Shyamlal.
Oh, Shyamlal.
Timing cannot be.
Oh, this Shyamlal is on a different context altogether.
Lordship.
This is 56B of our FRSR. Deadwood.
Lordship.
Deadwood, not a punishment.
I'm on the proposition, Lordship, because like, this is 72 is purely on
And
termination, Lordship.
the coordinate bench of this court, by following this in the earlier Lokimi Gaon Bank case, had drawn a conclusion that if it is compulsory retirement, you get everything. But unfortunately, this decision is on a different footing altogether.
Yes.
But that decision went up to the Supreme Court, got affirmed. So it's binding on us. But thing is, if you apply Shyamlal, Shyamlal would be applied in a situation which is FR 56. That is 25 years of service. His retention is found against public interest. He is asked to go. No department. If you come to para 22,
Lordship.
1, 2, 3, 4, 5, 6, 7, 8, 9. 9 lines of para 22
There is no such element
of charge or
Of charge.
imputation in case of compulsory retirement.
in the case of compulsory.
So if there is a charge, then it's a different footing altogether.
Lordship.
So this decision does not appeal to me,
If I may take your Lordship to Rule 72, Lordship.
because the case of Bolaram Bordoloi, this
Follow
court
up.
had
Lordship.
fully followed the case of Chamla.
Lordship.
Okay.
If I may just highlight Rule 72, Lordship.
Hmm.
Rule 72, my senior counsel is referring to Rule 72, 2E, Lordship.
Hmm.
This is purely for termination, Lordship. But termination cannot be treated.
Show me compulsory retirement in this context cannot be termed to be a termination.
If your Lordship sees Rule 39, Lordship.
Hmm. Hmm.
Rule 39, if your Lordship sees
Hmm.
Rule 39B, major penalties,
Hmm.
4 and 5.
Hmm.
This is 4 is removal from service, which
Hmm.
shall not be a disqualification for future employment, and 5 is dismissal, which shall ordinarily be a disqualification for future. The termination would mean dismissal or removal, but it cannot be a compulsory retirement.
See, all the three envisages a cessation of service, right? 4 and 5 is without any, because it also entails forfeiture of the past service. 3 may not entail a forfeiture of past service, compulsory retirement.
No, sir.
But it is up to them to pass up order, say, considering the gravity, loss, to authorize to you a pension. In 2018, the bank had formulated a regulation, pension regulation, and therein said that he may be granted pension at a rate not less than 2/3.
Lordship is referring to 31.
No, 31.
Yes.
But this 31 came in 2018, not in 2015.
No, sir.
What was the position in 2015?
Humble understanding, Lordship, termination cannot be termed as a,
That's why I asked you, show me how.
because in the act, it is nowhere defined.
Okay. But the learned counsel for the petitioners.
If your Lordship is passing an
Order.
order, Lordship may kindly hear my.
Further. Also, had the learned counsel for the parties further. Mr. S. Dr. Learned Senior Counsel appearing for the respondent number 5 bank submits that he be granted time till
Tomorrow,
till tomorrow to place on record the rule position with regard to release of pension and pensionary benefits to the officers and employees of the bank as on the date when the petitioner was imposed with the penalty of apostrophe B dot compulsory retirement. That is on 23/12/2015. Mr. Dotto had produced the Assam Gramin Vikas Bank bracket employees bracket over pension regulations 2018. However, it is seen that the said regulation would not have a retrospective effect as of 2015 when the impugned order was so issued, when the impugned penalty was so imposed upon the petition. Accordingly, registry to list this matter again. We'll have it on Wednesday.
yes,
On Wednesday. By slip query.
much obliged.
For further hearing. Huh?
My lord, I have a short prayer in regard to item 10. It is a part heard. My lord, can you lordship after 3rd June, can it be fixed?
After?
3rd June. 3/6.
Okay. On the prayer of Mr. S. Dr. Learned Counsel, Senior Counsel, appearing for the petitioner, registry to list this matter again on 4/6/2020.
Obliged.
But Mr. Dr. at 33%, 23% now disability, we leave the others, that would be going against you. And say this is hearing impaired. Your hearing may have improved. There is no material on record to counter that.
No,
On that
my
count,
junior who is conducting the case, he is a bit shaky.
No. Only on that point. The reservation point, it should be ideally RP 5 PWD. Again, I am with you in that. I'll draw my conclusions.
My lord.
Because when they prepared that roster register, RP 1 PWD was occupied by a OBC. So that point gets carried forward. So 2, 3, 4 filled up at that point of time. The next vacant post would be RP 4. RP 4 would be now unreserved and PWD. No issue on that. But what about this? This is going against you.
These are the matters I am not much familiar like your lordships. Your lordship
Oh,
is very.
this is not just something in my head. So if you
like to
can
be
give me a light on that.
Right.
Okay.
Obliged.
Oh, Mr. Das, you are here.
Yes, your lordship, my lord. I'm extremely sorry, my lord.
No, it's okay. It's okay.
I just missed the matter, my lord. It's a very simple matter, my lord.
Very simple.
It was a RO dealership for physically handicapped scheduled caste person, my lord.
Huh. Okay, Mr. Das, forget all those things.
Yes, my lord.
When did COVID end?
Yes, my lord.
When did COVID end?
My lord, in the year 2021, my lord.
2021, at a particular date, COVID was not there. Everything had become normal,
Yes, my lord.
right?
Yes.
Now, you say in your application that on the day when you applied,
Yes, my lord.
you had land which would have brought you within category 1 or category 2.
Correct, my lord.
But the documents, land documents, you came up before this court. This
Yes,
court
ma'am.
remanded back the matter.
Yes, my lord.
Now, still you had not, even as of 2023, when you had approached the respondents, you did
Yes.
not give any land details. Why?
My lord, because the first reason is that, my lord, they even refused to consider my case on merits with regard to the land documents. They have come
Forget
up with
it.
an...
Forget
yes.
it.
But after
This
that, my
court
lord,
give you a liberty,
My lord,
asking you to go there.
yes, my lord, last order of this honorable court, my lord will
I'm
kindly
coming
have.
to the last order. I'll come to the
Yes,
last
yes,
order.
yes,
I'll
yes.
come to the last order.
Correct, my lord. Yes.
Now, that time you did not submit any land document.
Yes, my lord, I submitted representation saying that you kindly give me time or
So-
chance so that I can submit the land documents, my lord.
Okay. What made you execute these agreements in 2025 when they had not even given you an extension?
No, my lord, challenging that denial, my lord, we have approached this honorable court and this
Denial to grant extension, not denial to consider documents.
no, documents are considered. This honorable court directed that they consider his land documents.
No, we'll come to that.
Never.
In
Yes.
23, when you approached the respondents,
Yes.
you had approached them seeking extension of time to submit documents.
Correct, my lord.
Yes.
My lord,
Denial of that, you came up before this court.
I wanted a chance since they put up a cutoff date of 49.
Okay, forget the cutoff dates.
Yes, my lord.
Let us get the facts clear. In
Correct, ma'am.
23, when you approached this court,
Yes.
it was not a grievance that your land documents were not being considered.
Yes, my lord.
It was because they are not giving you an extension for producing the land documents.
Fine, my lord.
That was denied, rejected by them.
Yes, my lord.
You come up in 2025 again before this court.
Yes, my lord.
Now you have land documents.
Yes, my lord.
Why these land documents were not there in 23 then?
My lord,
Nobody gave you permission to get the land documents.
no, my lord. Lordship will kindly appreciate. They did not even give me to enter into the door. They said at the threshold your case is rejected. Land, I could have, my lord, land documents I could have given at that point of time also.
No, you have not. You have executed this agreements only in
No, that's
November
fine.
2025.
Milord, my case is that, Milord, I was during COVID, I was unable to get the land because of I am physically handicapped. I could not move around and get it. Thereafter, after two opportunities, they canceled my candidature. So after the cancellation of candidature, I wanted an entry that you kindly give me some time so that I can produce the land documents. They did not give me. They said,
Okay, then why did you execute this in 11 when they have not given you permission? What
sorry,
did you
Milord.
execute? The land documents
Yes.
in November 2025. Why did you execute
Milord,
when they had not extended the time for you?
in the previous round of litigation, if your lordships kindly have the last order, previous round of litigation, when this matter came up, this honorable court, their objection in the impugn order therein was that I did not submit the land documents. This honorable court raised the query, why did you not submit the land document? You submit the land document by way of an additional affidavit before the honorable court. Then this honorable court passed this order, page 204. Implication of the order is that, if your lordships kindly read the order in entirety, the implication of the order is that whatever the delay ground you have urged, the respondent has urged in the previous round of litigation, forget about those things and consider his land documents on merit. He is a physically handicapped person.
Yes.
First of all, kindly see, my lord, on the day of application, whether he was physically handicapped or not, my lord. Page 50, my lord, kindly see.
Where have you raised that objection?
No, my lord. It's
That is
not
not
there
the
in the
ground
impune
when
order.
you, that is not the ground in which you have
Because
rejected the
the certificate was issued, my lord, it will be, even if it was considered, my lord, and this certificate would be verified during.
You verify.
Yes, ma'am. Now, my lord, kindly see page 55, my lord. This is a part of our guidelines.
Hmm.
Before my kindly see page 59 for a moment, my lord.
Hmm. Hmm. 59.
59, my lord. Note, my lord, in bottom, my lord. With regard to submission document by the select candidate, all certificate document required for meeting eligibility, specific eligibility criteria should be in possession of the applicant valid as on the date of application. His date of application is of my lord 22/12/18.
That was extended till the month of September 2019.
Yes.
And then the COVID and all those things.
Now, no, my lord. The COVID was, my lord, start, my lord. First, my lord, he was asked to produce the land, my lord, page 78, 13/3/21. Then second option was given to him, my lord, 14/6/21.
Now, Mr. Bhattakur, understand you have a guidelines.
Yes, my lord. No.
And
There is
this
a
is a
15 days time
situation,
limit.
this is a situation wherein all the persons who had there, one cancelled, two cancelled, three also rejected because they could not give the documents. So this petitioner, for some reason or other, he was eager and he gave you certain documents. This court directed you to take into consideration those documents. Now, in the impugned order, you have reiterated what you said
Yes, my lord.
while disposing of the earlier. Why this aspect of the matter was not
Now,
done?
kindly see the order passed by the coded bench, my lord. His neighbor said there, my lord, it should be considered at the recent time, my lord, whether it is registered. as on
Naturally,
12
that is,
No, my
what
lord.
what is very, very clear.
Now, but para 8, my lord, according to this code, therefore,
You
this,
see para 6,
yes, my lord.
227,
Yes.
207.
This court therefore fixed the matter on so and so, thereby granting liberty to petitioner file additional affidavit. In person, the additional affidavit was filed by the so and so, whereby land details of the plot of land within the advertised location as well as a memo understanding has been enclosed with the owners of the land in question, where it was agreed to that the owner of the land would lease out the
And
plot
see,
of land.
there is a COVID restriction going on.
No, my lord. My kindly see, that's why my lord, I am showing page 78.
78.
Page 7, it was issued on 13/3/21. The first option was given, my lord. On that point of that, the copy was not there, my lord.
No, no. State the restrictions were
No, my
on.
lord. It was, state is, my lord, the government of Assam issued the circular from May, my lord.
May till September.
Yes, my lord. Now, second option was, he was given, my lord, on page 7 and 14/6. There is a gap of 15 days, my lord.
So when was normalcy restored after?
My lord, 145, my lord, the 50% inter-district, my lord, was open, my lord.
That also was not the thing. Because people
But he
were
said that my
still being restricted.
Because his pleadings, my lord, he could not travel by bus or so and so, my lord. We cannot violate our own guideline, my lord.
My lord, I could
And so far,
appreciate the
the
respondents.
industrial notice concerned, my lord, but it has been issued on the basis of the application submitted by the concerned applicant, my lord. Kindly see the industrial note, my lord. Kindly see, my lord.
Mr. In 23, when you approached this court, 24, they had already rejected your case
Yes.
in 21. What made you
My
to
lord,
wait for
cut
2
off,
years?
my lord, yes, cut off date that, my lord, first they have given one extension, then second extension in the month of July, and the cut-off date was 14/9/2021.
14/6.
No.
Yes,
Kindly,
13/9.
Mr.
Sorry.
Bhattakur, July, 3 months
Yes.
time given, then it comes July, then September. So cut-off date was 14/9/2021. My lord, I could not submit the land during that period. Fine, my lord. That issue, thereafter I came before this honorable court. This honorable
No,
court
now
directed
tell
for...
me, Mr. Das,
Yes.
What were you doing for 3 years? Because in 22, there was no COVID.
Yes.
My lord, I was submitting continuous representation that give me an opportunity, but my submission is that, my lord, can you urge these grounds that Mr. Bothakur is urging right now after the last order passed by this honorable court? Because it is absolutely clear from the order that whatever is there, this person has filed an additional affidavit giving the document. Instead of passing a mandamus, this honorable court directed that you submit these documents through a representation. The entire idea is that they will consider my land documents on merit.
Okay. Heard Mr. H.K. Das, Learned Senior Counsel,
Now,
assisted by Mr. N.K. Sharma, Learned Counsel for the petitioner. Also heard Mr. S. Bothakur, Learned Counsel,
for respondent to
appearing for, also heard Mr. S.S. Roy, Learned CGC, appearing for respondent number 1, and Mr. S. Bothakur, Learned Standing Counsel, Hindustan Petroleum Corporation Limited, appearing for the respondent number 2 and 3. The petitioner in the present writ petition, in pursuance to
25/11/18
advertisement dated 25/11/2018, had submitted his application for being considered for allotment of a retail outlet dealership. What is the location name?
A location name is serial number 50, comma,
36.
Serial
number,
page 36.
it's there in the synopsis also, my lord.
At Dhansri Ghat to Urang on NH 15, Gelabil, Dorong district. They said location was reserved for scheduled caste candidates with PWD status. The petitioner having satisfied the said reservation status, petitioner had satisfied the said reservation status. So the materials brought on record reveal that the application submitted by the petitioner was considered in the category, in group 3 category, inasmuch as along with his application, the petitioner had not submitted particulars of any land. The materials further disclose that applicants who had been placed in group 1 and group 2, on consideration, their applications being rejected, it was the applicants in group 3 who were taken up for consideration. On such consideration being made, the petitioner being found to have been selected, the petitioner was via an email dated 13/3/2021 informed about the same and was directed to submit the particulars of the suitable land at the location in question within a period of 3 months. The period for submission of documents was thereafter further extended via an email dated 14/6/2021 till 13/9/2021. Also, the petitioner projects that on account of the restrictions put in place due to COVID-19 pandemic, the petitioner was not in a position to procure the requisite documents, and accordingly, the respondent authorities via a communication dated 23/9/2021 proceeded to cancel the candidature of the petitioner. So, the petitioner thereafter submitted representations praying for consideration of his candidature in terms of his selection for the same, for allotment of the dealership in question. Being aggrieved, the petitioner approached this court by way of institution of a writ petition being WPC number 6850/2024. A coordinate bench of this court-wide order dated 6/1/2025, noticing the grounds urged by the petitioner for the purpose of urged by the petitioners towards justification of the delay in furnishing the requisite particulars of the land at the advertised location, this court directed the respondents to take a decision on the petitioner's representation dated 8/11/2023. So, the respondents thereafter wide an order dated 3/4/2025 proceeded to consider the representation submitted by the petitioner in terms of the directions passed by this court-wide said order dated 6/1/2025. On a consideration of the same, the respondents proceeded to reject the claim made by the petitioner for being granted an opportunity to provide land under Group 3 for establishment of the dealership in question. The petitioner assailed the said order, said communication dated 3/4/2025 before this court by way of instituting a writ petition being WPC number 6126/2025. During the pendency of the said proceedings, a query having been raised by this court to the petitioner as to whether he had the requisite land documents at his disposal, the petitioner had proceeded to file an additional affidavit in the matter. So, thereafter, the coordinate bench of this court-wide judgment and order dated 19/11/2025 proceeded to direct the respondent authorities to proceeded to draw a conclusion that the land documents placed before this court ought to have been placed before the respondent number 2 and 3, rather than placing the same for the first time before this court. Accordingly, this court disposed of the writ petition by granting liberty to the petitioner to submit a representation to the respondent number 3, along with all such details for the land in question, and further provided that it shall be within the jurisdiction of the respondent number 2 and 3 to consider the same, taking into account that till date they have not been able to find any suitable PWD candidate for the advertised location. The respondent authorities, in pursuance to the directions passed by this court-wide said judgment and order dated 19/11/2025, proceeded wide order communication dated 31/1/2026 to reject the claim of the petitioner for being allotted the said retail outlet by opining that
Page 213, para 8.
that the petitioner, having not submitted the land documents within the extended period as granted to him, the land documents subsequently submitted would not be in conformity with the dealer selection guidelines 2018, and accordingly the learned counsel for the petitioner has projected before this court that the respondent authorities had projected before this court that it was only on account of the inability on the part of the petitioner to procure the documents, on account of the restrictions put in place at the relevant point of time due to COVID-19 pandemic, that he was prevented from the same could not be placed before the respondent authorities. He submits that he had time and again approached the authorities praying for further extension of time, considering the restrictions in place on account of COVID-19 situation. The learned senior counsel for the petitioner further submits that this court, while the judgment and order dated 19/11/2025 had appreciated the said contention of the petitioner, as well as the contention raised by the learned counsel for the respondent, that the respondent were unable to find a suitable candidate for the advertised location in question for allotment of the dealership in question, and accordingly proceeded to pass the directions for a consideration of the case of the petitioner. The learned counsel for the petitioner submits that such consideration ought to have been made not with regard to the delay occasioning in submission of the land documents, but with regard to the land documents brought on record by the petitioner while his representation dated 19/12/2025. Accordingly, Mr. Das submits that the respondent authorities are required to be directed to consider the case of the petitioner on merits and thereafter to arrive at a conclusion with regard to his eligibility for being allotted the land in question. In other words, he submits that the respondent authorities ought to take into consideration the land documents now brought on record before the respondent authorities. Mr. S. Bhattakur, learned counsel for the respondent number 2 and 3, has placed on record a mail received, has on instructions submitted that the advertised location in question in the present proceedings was dropped by the respondent authorities as no eligible candidate was found available for further consideration in the selection process. The said decision of the respondent number 2 and 3 would reveal that the dropping of the advertised location in issue in the present proceedings was only on account of the fact that there was no eligible candidate in the fray for being considered for such allotment of dealership. The petitioner, having submitted the requisite land documents, in the event this court requires the respondent authorities to consider the same specifically, then it cannot be held that there was no eligible candidate available for the advertised location. Also, the issues arising in the matter, the rival contention of the learned counsel for the parties have a rival contention of the parties to the present proceeding would require a deeper consideration, and such consideration would be permissible only after the respondent authorities have filed an affidavit in the matter. Also, issue notice, returnable 4 weeks. You all appeared 3 weeks. 3 weeks. Mr. S.S. Roy, learned CGC, accepts notice on behalf of respondent number 1, while Mr. S. Bhattakur accepts notice on behalf of respondent number 2 and 3. No formal notice, requisite extra copies. In view of the above discussion, this court is of the considered view that until further orders, no fresh advertisement be issued for the location Dhanasri Ghat to Urang on NH 15, Gelabil, District Dorang, Assam, as advertised, while the advertisement dated
25/11/2018.
Milord, one small prayer, Milord. the instruction which has been placed before your lordships that they have decided to drop, my lord. My lord, this is required to be state. Otherwise, my writ petition
I
will
have
become
said,
invalid.
I have said that, I have clarified that if we accept your principle, that if we accept your reconsideration is to be made in your case,
Yes.
then this would be infractious. I've already said
Fine.
that.
Fine, ma'am.
And we have state further advertisement. So your rights
Yes.
are taken care of.
Look, this is second time this is happening in this such RO matters. When a case is made out, my lord, they drop the my lord, the location.
They have dropped the location only. See, there are two dropping. One,
Yes,
it's not feasible.
correct.
We don't want it.
They have
That is the first question I asked him.
correct.
Then
my
you
lord.
have got no case.
Correct. my
Here
lord.
the dropping is because there is no eligible candidate.
Correct. I am there.
You are there if you come in there. But
Exactly.
Mr. Das,
Yes.
2021 to 2023, why no land document? This is what you have to tell
My
me.
lord, I'm
You have
only,
to tell me when you have to tell me.
I'll satisfy, but I'm shocked because a physically handicapped person, scheduled caste
No, my
person
lord,
has been
but this is
dragged for
absolutely
2 rounds of litigation, for this simple issue. Are you not doing this as a welfare activity? Lord, I'm on another point.
let them show, my lord, his certificate is
Technically, my
genuine.
brother can
On the
argue
day of
that you have
application,
not
my lord.
submit.
It is after two.
Oh, wait. Let
Mr.
him have
Bothakur.
his thing out. Yes.
Lordship can hear Mr. Bothakur. He has got
No,
some
no, you
urgency.
tell me.
No, technically, my lord, they may raise several objections. No problem. You raise your objections, but the thing is that for what purpose you have issued the advertisement, you have forgot about your entire purpose. You are having a physically handicapped person, 75, who is eligible. You find me to be eligible for this hyper-technical reason.
Mr.
land
Das,
document.
Mr. Das, along
Yes.
with you, this RO was advertised only for SC PWD.
Exactly.
So all the applicants who are there, it's not only that there are other applicants also.
Correct, my lord. So they
So
could not find.
tomorrow, if we have to allow, we may also have to consider direct for consideration. What benefit we give you, we'll have to give them also.
Yes.
Keep that in mind.
Correct, my lord. Lordship is correct, but as on date, I am standing.
It is
before
only between SC PWD.
Yes.
So whoever are there, you coming to court, you have been the pioneer, you have opened the road, but the road construction may not be by you. It may be somebody else also. Keep that in mind.
Much obliged, much obliged, deeply obliged.
Today you are protected.
Fine. Yes, I'm
But
okay.
this 23 thing if this matter comes back to me for hearing,
I'll
21 to 23 you will have to explain.
I'll satisfy your lordships every day, my lord.
Yes.
Much obliged.
Lordship, here your lordship has asked me to produce a certain instruction written, lordship.
May it please, your lordship.
Yes, Mr. Pugan.
Lordship, I'm appearing online, lordship. This matter, I have also got my instructions, my lord. I have given a copy to the my lord court master, my lord.
And
Sir.
Mr. Sharma, take one copy of that email from, it will help you.
Lordship, I inquired with the GASA department, my lord. That is the main department from which the accounts section is handled, my lord. Has the lordship got the thing, my lord? The letter?
Now the irrigation department says,
Your lordship, they haven't served me any copy, my lord.
no, okay, fine. You have also not served them a copy.
My lord, I received today, my lord.
He also received today.
My lord.
It is further stated that the salary and other office expenditures are met from the grant 11 at General Administration, Secretariat and Attached Officer with the budget allotted by the General Administration Department to the Irrigation Department.
I'll have to take instruction on that, my lord.
No instruction.
Because why, my lord? In this, as per our
anything, any irregularity, Mr. Fukon,
my lord.
your rules will also provide for that relaxation. Do it. Bring him within the fold. regularize his service, and thereafter he found suitable, promote him.
Lordship, my contention out here, my humble submission is that if your Lordship comes to my affidavit, my Lord, there itself we have said that the appointment of the petitioner is dehost the rules, because my Lord, the rules which
Rule says that it should be by the under secretary, by the deputy secretary.
My Lord, there are two things. Lordship, kindly come to the rules, my Lord. Kindly come to the Assam Secretariat Grade 4. This is the same rules which he has relied on, my Lord. The Irrigation Department.
Yes,
This is Assam Secretariat Grade 4 and Record Suppliers Service Rules, my Lord. Now, this cannot be, they cannot go, my Lord, dehost the rules, my Lord. The rules is specific, my Lord, and it's categorical, my Lord. Kindly see the definition 2, my Lord. In these rules, unless there is anything repugnant in subject or context, my Lord, Lordship will kindly see.
Appointing authority means the deputy secretary to the government of Assam.
Appointing authority means the deputy secretary to the government of Assam in the Secretariat Administration Department. And in this case, if there is no deputy secretary, it is as under secretary, my Lord. But my Lord will kindly see one thing. If a Lordship comes to the appointment of the Annexure A, that is directly, my Lord, an irrigation department under secretary, my Lord. Not even a person who's from the SAD. So why should the SAD take responsibility of that, my Lord? Because they have gone totally dehost the rules, my Lord. This is because they have not applied the rules and they have appointed somebody whom they could not have appointed. Now, my Lord, now in the point they have reached a point where they are trying to shift the blame on the SAD, and SAD has categorically stated in there, my Lord, in the letter, my Lord, that the DDO which they draw, there also there is no person. My Lord will kindly see the DDO again, my Lord, the letter, because the DDO, it says specifically that, my Lord, with reference to the subject cited above, I'm directed to inform you that as per available records of the GA-SA, Secretariat Administration Department, there is no record of Sri Upenda's MT as irrigation drawing any salary from the DDO, GAD Secretariat accounts. So this is the main department accounts. If they don't have any records, my Lord, how can we accommodate him, my Lord, when he is not under us?
Lordship,
So that is the moot question, my Lord.
I am allowed to submit certain document, additional documents, Lordship. In similar circumstances, Lordship, what happened, Lordship? The first and second page is same page, same Lordship, same letter, Lordship. Here I am concerned with serial number 4, Nurman Ali, Lordship.
Serial number 4, Nurman Ali.
He was appointed by the Undersecretary Irrigation Department, Nazarat Branch, Lordship. Page 2, Lordship, you kindly see, it is somewhat not properly legible, but it can be readable, Lordship. It is Irrigation Department, Lordship, below, Lordship. And page, third page, Lordship, he has been promoted by the SAD, Lordship. Page serial number 4, Muhammad Nuriman Ali. And Lordship, the last page, Lordship, kindly see. They have asked all the departments to submit the, Lordship.
They have not brought that on record, my Lord. They are just giving, my Lord.
I am just placing me with the court.
And the Dinesh Singh case also, my Lord, does not apply to them, my Lord.
And Lordship, the rule also, Lordship, if Lordship comes to the page, the definition 2, Lordship, Roman 2, Lordship, Assam Secretariat means all departments of the government secretariat, including Chief Minister Secretariat, but excluding the PW Secretariat, Lordship. So irrigation included here, Lordship.
You are getting your salaries regularly.
Since my appointment.
How could you appoint him? That's my question.
Regarding the appointment, Lordship,
Because this appointment ought to have been from the SAD, not from your department. Your department has got.
I have just shown another instance, Lordship.
That is an illegality. Now this issue is before us.
Lordship.
How can we ignore that?
This is Article 309 back rule, my Lord.
as per instruction from the petitioner, Lordship, similar situated various persons appointed that time by the various departments, under secretary, deputy secretary, elsewhere.
Somebody had asked them appoint, so appoint. Now the SAD is to be.
From the exchange department, for proper channel. Lordship.
Employment exchange.
Employment exchange. Lordship.
But that appointment, because what I know, what I understand is,
Lordship.
In the SAD department, it is the SAD employees. He may be in PWD today, tomorrow irrigation, day after tomorrow somewhere else. The concerned department does not have a power to appoint. It is the SAD who will appoint.
Appointment was in the year 1989. First policy, they have taken their time lordship.
Okay.
I'm only for regarding my promotion lordship.
Your appointment is in, if I hold something against you, your whole thing goes. First, you have to have a seat. And then only you can come. Now, if I hold against something against you, your whole service from 89 goes. You will not be held to be in CADA. Okay. Hey, Duta was a Duta Dishun. We'll pass the orders in the second.
Well, obliged, madam, deeply obliged.
Obliged.
Lordship has already heard this matter, Lordship. With regard to WBC 3164 of 2004, that is pertaining to Lordship recovery of an amount of 86,154. On the last occasion, your Lordship.
We will see 2023, 4500-2023.
Lordship.
Here, Mr. Das,
Lordship.
what is your prayer?
Lordship, during the pendency, Lordship, pension payment order has been issued. Now my prayer is for Lordship interest as per Rule 197A, Lordship. Because there is a delay of Lordship 1 year, 5 months. I retired from service, Lordship, on 31/1/2023. And Lordship, I got my
When
provision.
did you deposit the excess amount?
Yes, Lordship.
When did you deposit?
On 15/6/2024.
So when did you retire?
I retired on 31/1/2023.
31/1?
2023.
23. And you deposited the excess amount on?
15/6/2024.
And the PPO was issued on?
Lordship, it was issued on 24/2/2026.
Normal. There is no excessive delay.
Lordship, the delay.
Now that recovery amount, you want it back, that's all.
Lordship, then delay, Lordship, delay of 1 year, 5 months. I'm legally entitled.
That we are. Because you were getting a provisional pension in the meantime.
So that provisional pension was also got delayed, Lordship, by 1 year, 5 months.
But you got the provisional pension from the directions of this court. So that is taken care of. Now, what do you have to say about the recovery?
Recovery, Lordship, it was not attributable to me. No so-cause, no nothing, Lordship. And Lordship, I have, because of Lordship.
See, Mr. Das, there are two things.
Lordship.
One, why the recovery was made.
Lordship.
That is can be an issue. Two, the recovery itself. Now, in the writ petition, it is the recovery that is being questioned, not the reason for that recovery. That ACPS grant of some amount was given to you higher. So you have not made any statement with regard to that. That is correct, that is wrong, this is back. You have not said.
Specific government was.
Where?
That is not attributable to him, Lordship.
Huh?
Wrong fixation is not attributable to him, Lordship.
Oh, that is why you get back the recovery. No problem. I'll give you the amount back.
Yes.
But how can you get that, get the higher stage of pension? Pay emoluments cannot be at the higher stage. It has to be at the rectified stage.
Okay.
Now, this issue, you have not raised anything. 86,000, you are getting it back. Take it from me. Allowed. But the fixation, they say, was made because the ACPS grant that was given to you was given at a higher stage. So they rectified it, brought it to the lower stage. Excess paid was 86,000. That they took from you. That I'm giving back. But what about this ACPS thing? You have not said anything here.
So I'm not able to say how they have calculated losses, whether it was good.
That there is no pleading, Mr. Das. That's what I'm asking you.
Was it from the pension payment order also, it is not reflected.
That because by that time everything was rectified
Okay.
and they sent it in the normal scale. So we'll only say the stage, rectified stage, you get it, but you will get back, they'll pay you back the withheld amount, the recovered amount, 86,154.
With regard to lots of interest also.
Interest, we are rejecting that.
There is apparently lots of 1 year, 5 months delay.
But we give you the, you are getting a provisional.
Provisional pension was also got delayed by 1 year, 5 months. Also.
Okay, fine, no problem. Those are normal things. First writ petition is of infractors now. The second one we'll have to pass the order, right?
Okay. Can I place the judgment with regard to interest?
Anything more?
And also the third judgment also the relevant paragraph I have just given.
That's it. 5 years delays were there in those cases. Yes, you have nothing to say. Yes, madam, you are appearing for?
The education department.
Why the delay?
It was, but it is from the finance department to grant pension and to verify whether the reason lordship.
You are responsible.
For a delay lordship,
Yes.
but for
You are to, finance is not to process, you are to process.
pension department.
Send it to the director.
Lordship, we've sent it to the director.
When did you send?
Lordship, date. Lordship, we don't have record lordship the date, but we have sent it to the pension department and this.
No, that is why the pension payment order, but he says that while processing it, there was a delay of 1.5 years.
Some lapse on our part, but lordship.
So that lapse,
How the final outcome has come.
that lapse, how will he?
Sanction the provisional pension.
Lordship,
He loses.
Lordship, that's a provision pension was sanctioned to him, lordship. Means that lordship too.
Okay, disposed of.
Our names may be recorded. Our names may be recorded.
Everything, bold letters. Others will be in simple, yours will be in bold.
Much obliged.
None.
Obliged.
In both the cases, you are appearing. And Mr. Pegu, who will appear for that? Huh? Pension, okay.
I appear in 9 only, my lord.
P. Sharma 9 okay. I'll pass the order.
Please, Lordship, kindly pass over the matter for the timing.
My lord, here I have a prayer, my lord. Yesterday, one of my relatives is in hospital, so I could not prepare it. Can it be on next week, Monday? Lord?
On the prayer of the Learned Council for the parties, registry to discuss matter again on Monday.
Really obliged, my lord.
Correct. Father, hearing.
Lord, I have not heard the item number. What was the last?
Now 12. 12 is the item.
My lord.
You have come at the appropriate time.
My lord.
Mr. Chamua,
My lord.
NPS scheme was introduced
2004.
sometime in 2000, December 2020, 2003. The scheme was introduced for whom?
My lord, this scheme was introduced for the persons who joined on or after 1/1/2004.
Central government had introduced that scheme for whom?
For its employees, my lord.
For its employees,
Yes,
right?
right.
Then it was operated, implemented, irrespective of whether they are a central government employee or not. Even employees in the autonomous institutions like Mr. Goswami's clients were given that NPS thing, were brought under NPS.
Yes, there are notifications, my lord.
Fine. But that notification, initial notification is again government employee. Right?
But so far as, may I reply to this? Yes, government employees, but the employees of our central university is also government employees, my lord.
You accept that?
It is a state, it is a state with the meaning of Article 12.
Huh?
It is a
So
state.
they are also, you accept that they are also government employees?
Yes, yes.
Yes, give them that benefit. UGC says they are government employees. Anything left to be decided? We are passing the order.
Lordship, Mr. Cal will submit, Lordship.
Huh?
Mr. Cal will submit, Lordship.
Get him. Thank you, Mr. Chomo. Your grievance is redressed. We'll record your statement and pass the orders. You have done.
There are notifications issued that is the applicability of this scheme has been notified, and this will be applicable according to this notifications only.
So you say that they are also entitled to that.
Entitled to what, my lord?
To NPS and exclusion from NPS, both.
No, NPS or OPS, my lord.
They were brought under NPS as they are also central government employees.
Yes.
Now, certain category of central government employees have been brought back from NPS to OPS.
OPS, yes.
So these people also satisfy those criteria. So they'll also go back. Simple.
If they satisfied, then they will be coming back.
So their case also advertisements were before 31/12/2003.
Yes, if these criteria are fulfilled, then why not?
See, such a great person.
My lord.
Thank you, Mr. We'll have your thing. We'll record it and then we will pass the. Get Mr. Cal. Give us some time, Mr. Chomua.
My lord.
Public. So, Mr. Goswami, nothing is to be decided. But Mr. ABT Hop, Learned Council for the petitioner. Where is Mr. CKS Borua? Call him. We are dismissing your petition.
A small submission, Lordship.
Forget that submission. How are you being promoted from laboratory assistant to assistant chemist?
Correct, Lordship.
Huh?
This is correct.
I wanted that instructions only to see how the director had done it.
But Lordship,
We'll take up Mr. Chomo, you are there?
Yes,
I am here, my lord.
He for UGC.
He's for UGC. Now, Mr. Cal,
Lordship.
Mr. Chomo has submitted that the petitioners are government employees. So that is the reason why NPS was applied to them.
Yes, Lordship.
And now the exclusion of that specific category in whose case advertisement was from 31 was before 31/11/2023 will also apply to them. That is the statement of
No, Lordship,
UGC.
if the UGC said that the employees, we have to follow. Yes, Lordship. Because their instruction is there, Lordship. Initially, we asked them to submit their inputs, Lordship. Thereafter, we receive a communication from the university, UGC, that they are not because Assam University is a autonomous body, so they are not covered by the notification.
But Mr. Chamua, under instructions,
No, if
we
file
an
affidavit, we file affidavit.
You have filed an affidavit.
Yes.
Where have you taken this plea there?
My lord, Lordship can come to page, my lord. My internal page is 5 and running page is 224. Paragraph 11 onwards, if I may read, my lord. Has your Lordship got it? Page number may not be, my lord, similar that I am having, my lord, because of this running page number may not be same.
Now come to para 12.
Yes. The Ministry of Education, by its letter dated 18/8/23, clarified that
Mr. Kel, please have a seat. Somebody just sent for SK Goswami.
May I read, Miller? By letter dated 18/8/2023, clarified that the DOP OM dated 3/3/23 has been issued subsequent to the OM dated 17/2/20. With regard to the OM dated 17/2/2020, the Department of Expenditure has made it clear that the said OM is applicable to central government employees only and not to employees of autonomous body. The UGC, by its letter dated so withdrawn its letter dated 21/3/2020 as per communication received from MOE stating that the DOP a letter dated 3/3/23 regarding coverage under CCS pension rules in place of National Pension Scheme system of those central government employees who were recruited against the post of vacancies advertised notified for recruitment on or before 22/12/2003 is applicable to central government employees only and not to employees of autonomous bodies. A copy of the letter that shows employees here with except for. Oh, this stance has been changed, Miller. I'm so sorry. This stance has been changed because
Mr. Chomuha, being a standing counsel UGC, you have made that statement, which is clearly contrary to your affidavit.
Yes, right, Miller. I apologize.
Either you are not prepared or you made it. This is not acceptable.
No, Miller. I skipped this portion, Miller. When I submitting, I just read the first portion.
You led the university to pass a contrary order. That's it. Because we are not covered, we will not give it because they proceeded.
Well, later on, kindly see the initial notification was of 2003-04. Then the withdrawal notification was issued in 2020.
Okay, we have heard you enough. You have confused us enough.
No, sorry, my lord.
This is not accepted, Mr. Bo. That's why I said we are recording your statement and proceeding.
No, my lord. What is on record in writing, my lord, that has to be considered, my lord.
Why? That is for you to project, not for me to see.
Yes.
You have projected in a different manner. We will record that and we will proceed.
No, my lord. What is on record, lordship will consider that.
Not expected from you, Mr. Tomo. I was surprised. I was surprised when you made that.
No.
We also come reading.
No. Yes, I understand, my lord. What your lordship was asking me, forget it. Whether they are government employees or not. They are government employees. There is no doubt on this, my lord, because they are the state instrumentality.
If they are government employees, then why is UGC taking...
Exceptions are carved out in 2020, my lord.
That's it.
By an
if they
executive
are of autonomous body, they are not government employees.
Yes.
They cannot be treated as government employees. Employees of Assam University are not government employees per se.
The exceptions are carved out in...
there is no... You have not read your brief. There is no exception carved out. It's a wrong application of the whole thing. We'll clarify that. Now tell me one thing. Come to that 3.3. At page 190, you can have it both in the writ petition as well as in the 92 of the writ petition.
Page 92.
Hmm.
Yes, my lord.
Read the first paragraph.
The undersigned is directed to say that the consequent on introduction of National Pension Scheme by Ministry of Finance dated 22/12/2003, all government servant appointed on or after 2004 to the post of
You
Central
mind the words all government servants. Right?
Yes,
Are mandatorily covered under the scheme. The Central Civil Service so and so, and after the amendment, those rules are not applicable to government servants appointed to government service after 31/12/2003. Right?
yes,
Then I'll tell you what happened. Then on 17/2/20, next paragraph,
yes, my lord.
a decision was taken that wherever selection was completed prior to 31/12/2003, appointed after 1/1/2004, those people will also be brought within the NPS, within the OPS.
OPS. OPS, my lord.
Now, having done that, there were in many cases, even the High Court, Delhi, Central Administrative Tribunal, wherein the courts held that no, if the advertisement is issued prior to 31/12/2003, recruitees, even if appointed after 1/1/2004, will be covered by OPS. And accordingly, this came into being. Now, what you have done is, UGC, you have, moment this had come, you had circulated it to all the universities. They applied it. Subsequently, when the ministry gave some clarification that this is only for government employees, it doesn't say any further. It's only for government employees. You withdrew that. So they also did not apply the OPS scheme to the petitioners. They were left hanging. And now they have come here. So if they are not government employees, how did you apply NPS at the first stage before them? They'll continue to be covered by Central Civil Service pension rules. They cannot be brought under NPS also.
That is for them to take a call for a
No, that is because of your direction they are doing it. You have to clarify now.
But my affidavit is silent on this point. my lord.
Your affidavits are only to one point. After that, it's not there.
No, yes.
That is not
what
mine.
I'm saying.
That's not our lookout. We'll
That
only
is
go
what-
what your stand is.
Then
Now
my
you
lord,
come to
I have to
come to
take
your
further
page,
instruction.
to no instruction 237.
In my respectful submission, my lord, if the OPS was applicable to the university employees under the 1972 rules, then, my lord, this is my understanding. Of course, this is not the instruction from my client.
Forget which is not your instruction from your client. Don't make those submissions and put yourself into trouble now. Yes, Mr. Kyle. Why did you apply NPS to them if you are not government employees?
No, Lordship, what happened earlier, we received notification from the
Where is that notification? That apply this? I want the NPS notification, not the subsequent 2003 notification. The NPS notification. You are covered by CCS pension rule because you have adopted it.
Yes, Lord.
Now, if the government says that they are not government employees, accordingly not entitled to the benefit of 3/3/2023, they should not be brought within the NPS.
Lordship, that way, this is our clarification, Lordship, in our affidavit.
Where?
Lordship, I'm just. Page 185. Paragraph 4.1. The Government of India, Ministry of Personal and Public Grievances and Pension, Department of Pension and Welfare, White Office Memorandum dated 3rd of March 2023 issued notification regarding coverage of all the central government employees under the Central
No,
Civil
I'm not on that. I'm not on that. The earlier notification introducing NPS, Mr. Kale.
That is not there.
No. That was also for central government employees only.
Yes, Lord. Lordship, there was a confusion in the university, so we requested all the employees to submit their papers.
They have.
Yes, they submitted, but in the meantime, we received another notification from the UGC that the autonomous body employees are not the central government, so it
That
will not
cannot be.
applicable. Lordship, that is
If they are not central government employees, the NPS scheme cannot be applied to them. We'll declare that. They'll all continue to cover under the CCS pension rules because you have adopted that.
Hardly, because Lordship, we are bound by, we have to follow the instruction of the UGC. Lordship.
UGC is neither here nor there. It's just us acting as a post office.
No, that is
That's
why.
all.
Lordship, if direct Lordship, then we have no objection. Lordship.
We'll direct.
Lordship.
Anything more, Mr. Goswami? Mr. Chomwa, you have anything to say?
No, my lord, I cannot go beyond the affidavit, my lord. That is
Okay.
my.
But your initial
And
statements,
whatever my mistake, I apologize for.
Yeah, okay. Accepted.
Yeah, thank you.
Lekha. But Mr. S.K. Goswami, Learned Counsel for the petition. Petitioners. Also heard Mr. S.C. Cal. No.
For 6 and
Also heard
7.
Mr. Pegu, G. Pegu, Learned Standing CGC, appearing for the respond number 1, 2, 3, and 4. Also heard Mr. A. Chomuha, Learned Standing Counsel, UGC. Mr. S.C. Cal, Learned Senior Counsel, assisted by Mr. K. Jain, appears for the respondent number 6 and 7. The Learned Counsel for the parties have been heard at length. Hearing concluded, registry to list this matter on Thursday for delivery of orders. 2 p.m.
Thursday, Lordship, probably our High Court is closed.
Okay. Friday. 2 p.m.
Obviously.
Be careful when you make submissions.
I apologize.
Yes, Mr. Burua, any instruction?
Yes, Lordship. Basically, that letter by the director, Lordship, have disowned that.
Okay. Heard Mr. ABT
Lordship, kindly see the instructions.
ABT Hawk, Learned Counsel for the
Small
petition.
submission may come.
Also heard. Yes, Mr. Hawk.
What happened, my immediate senior promotional post, senior laboratory technician, this is blocking Kedar Lordship, 2 posters there. The 2 persons, those the incumbent, they are permanently Lordship ineligible for next post, Lordship. So now what will happen, Lordship? I am depriving the promotion, Lordship. I am the qualified.
We will say that you have been favored. And we
That's
will
why
direct
DPC
that proceedings against you and the director be taken up.
That's why, Lordship, DPC have taken the.
There is no DPC. That DPC has been disowned in the affidavit and you have not replied to that. There is no minutes. It's the director who had done it.
Yes.
No, Lordship, if that's so, Lordship, in this regard, I will obtain instruction.
No, enough is enough.
She has. This is the annexa, Lordship, in this writ petition, the meeting, Lordship, DPC meeting.
Laka. Heard Mr. ABT Hawk, Learned Counsel for the petition. Also heard Mr. CKS Borua, Learned Government Advocate, appearing for all the respondents. The petitioner in the present petition has prayed for a direction upon the respondent authorities to promote her to the post of assistant chemist from the post of laboratory assistant presently held by her in the establishment of the Directorate of Geology and Mining. In terms of the recommendations of the Departmental Promotion Committee purportedly held on 9/12/2024. Also, the petitioner in the present petition was appointed as a laboratory assistant in the Directorate of Geology and Mining, Assam, by an order dated 31/3/2015. Also, the incumbent director in the post of the director of Geology and Mining Assam via a communication dated 19/11/2024 submitted a proposal before the government in the Mines and Minerals Department for considering the case of the petitioner herein. Requesting for permission to effect promotion against one post of assistant chemist lying vacant by way of promotion from the cadre of senior laboratory technician as well as the cadre of laboratory technician with the qualifications as set out therein. It is projected that in pursuance to the said communication, a meeting of the Departmental Promotion Committee was convened on 9/12/2004. Also, the Director, Geology and Mining, thereafter, via a communication dated 18/1/2025, intimated the government in the Mines and Minerals Department that the Departmental Promotion Committee, in its meeting held on 9/12/2024, had recommended the name of the petitioner, who was a lab assistant, for promotion to the cadre of assistant chemist. Also, the said promotion not being approved, the said recommendation not being approved, and orders not being issued to the petitioner promoting her as assistant chemist, led to the institution of the present writ petition. I have heard the learned counsel for the parties and also perused the materials available on record. The learned counsel for the petitioner has reiterated the facts noticed herein above and has submitted that the respondent authorities, having considered her case for promotion to the post of assistant chemist and the Departmental Promotion Committee having recommended her name, there was no reason as to why consequential orders promoting her to the post of assistant chemist should not be directed to be issued. Mr. C.K.S. Borua, learned counsel for the respondents, by referring to the affidavit filed in the matter, has submitted that the post of laboratory assistant in terms of the draft rules in operation of holding the field is not the feeder post for promotion to the cadre of assistant chemist. The purported recommendation made by the Departmental Promotion Committee in its meeting held on 9/12/2024 was disowned by the respondents in the affidavit, and it was highlighted that there is no minutes of any such meeting of the Departmental Promotion Committee available on in the records of the Directorate. It is submitted by Mr. Pukan that by Mr. Borua that the communication dated 18/1/2025 issued by the Director, Geology and Mining, is projected to be one so issued in his individual capacity, inasmuch as
I could not file reply lordship due to her father expired on before last week lordship. She could not come. Her mother also hospitalized. That's why I could not file the affidavit. There is a record lordship in the DPC, but they don't know why they have proceeded.
TPC can only consider in terms of the rules.
Rules, this is
It cannot
correct,
go
Lordship,
beyond
but-
that.
Go ahead.
Lordship, this is correct.
So, is so and so, Vakil Hisham? Inasmuch as there is no basis for issuance of the said communication available in the records of the directorate, and further no approval is also seen to have been received with regard to the same from the government in the Mines and Minerals Department. So, Mr. Borua has further submitted that the promotion of the petitioner in terms of the rules holding the field would be permissible only to the post of senior laboratory assistant and not to the post of assistant chemist. I've heard the learned counsel for the parties and peruse the materials available on record. The service conditions of the petitioner is governed by the provisions of the Assam Geology and Mining Service Rules 1988. The said rules is in the draft stage. However, as contended by the learned counsel for the parties, the same is being reckoned for the purposes of recruitment and promotion in the directorate. Also, Rule 3 of the said rules set out the cadre of the service and the post of assistant chemist, senior laboratory assistant, junior laboratory assistant, and laboratory assistant form distinct posts in the cadre of the service. Also, Rule 4 bracketed B provides that the post of assistant chemist, senior laboratory technician, laboratory assistant shall constitute the same group. Also, Rule 5B mandates that the post of assistant chemist is to be so filled up by way of promotion. Also, the feeder cadres for promotion to the various cadres of the service is provided under the provisions of Rule 17. Rule 17(1)(d) mandates that the incumbent in the post of laboratory assistant would be entitled to be considered for promotion to senior laboratory technician, while Rule 17(1)(e) mandates that the incumbent in the post of senior laboratory assistant would be eligible for consideration to promotion to the post of assistant chemist. Accordingly, for promotion to the post of assistant chemist, the feeder post is the post of senior laboratory technician and not laboratory assistant. Also, the projections made in the present petitions would go to reveal by the petitioner would go to reveal that she was considered for promotion to the post of assistant chemist by the duly constituted departmental promotion committee. The said contention was disputed by the departmental authorities by way of filing affidavits as well as placing on record written instructions to Mr. C.K.S. Borua. Be that as it may, even considering that the petitioner was in fact considered for such promotion by a duly constituted departmental promotion committee, such consideration extended in respect of the petitioner would be of no consequence inasmuch as the same is not as per the provisions of the rules of 1988 holding the field. The rules of 1988 having mandated that the feeder cadre for promotion to the post of assistant chemist would be that of senior laboratory technician, the petitioner who is only a laboratory technician, laboratory assistant, senior laboratory technician who is only a laboratory assistant would not be entitled to be considered for such promotion. Consideration with regard to promotion in respect of an employee would be permissible to be so extended to the employee strictly in accordance with the rules holding the field and to the promotional post as identified in the rules. Accordingly, the petitioner, not being in the feeder cadre for promotion to the cadre of assistant chemist and nothing having been brought on record with regard to an amendment being made with regard to the provisions existing in this connection in the rules of 1988, the claim made by the petitioner for a direction upon the respondent authorities to promote her to the post of assistant chemist would not mandate acceptance from this court. In view of the above discussions, this court is of the considered view that the petitioner, in terms of the provisions of the rules of 1988 as holding the field as on date, would not be entitled to a direction for having a case entitled to a direction for consideration of a case for promotion to the post of assistant chemist. Accordingly, the claim made by the petitioner in the present petition is held to be is not mandated to be accepted, and accordingly, and the present writ petition is held to be devoid of any merit. Consequently, the writ petition stands dismissed. However, there would be no order as to us. Sorry, Mr. Bhatt, can't help it.
So what will be my promotion? Could I apply for next higher post closing? This is a blocking cadre.
You go for direct recruitment.
This is one vacant promotional post.
They have
is
not
there.
passed any order, but last time I stopped myself because I wanted to pass adverse orders against the director and you. I've excused you.
Obliging.
This is not done. Yes, where is the additional affidavit?
Yes, we have received the instruction, Lordship. Kindly give us some more time to file our affidavit.
Their guns would get rusted now by the delay. Huh? Now they can't operate it also. You are cleaning it daily. Says Guru, Learned Counsel for the
Yes, sir,
Learned
Guru.
Government Advocate submits that the additional affidavit in terms of the directions passed by this court, additional affidavit on behalf of the respondent shall be filed on or before. On or before, when?
Lordship, after 2 weeks,
You give me a date.
25, no, on or before 8, Lordship.
8. On or before 8/6/2026. Registry to list this matter again on 10/6/22.
Deeply Lord.
Obliged, Lordship.
ওপৰৰ এটা থাকি গৈছে নেকি? এটা 2টা বজাততো এটা এটা আছে।
Wait, please, Your Lordship. My lord, there is a, my lord, direction, my lord, Your Lordship, by order dated, my lord, 27/2/2026, my lord, Your Lordship, para 8, my lord. May I read, my lord, para 8. From the above direction made by this court, it is transparent that it is the district commissioner who has conducted an inquiry and thereafter to decide on issue whether Ilakili is a part of Bolahi Sampora fishery. Similarly, it is the state government in the fishery department who has to decide whether Betoli Bill is a part of any registered fishery or not. Therefore, it is the respondent number 1 and respondent number 4 who has to place on record and decision taken.
Yes.
And my lord, that part they file affidavit by
When?
by the my lord, respondent number 1 and 4, my lord.
When did they file?
File on 25/2026.
20?
205/2020.
It's not on record.
Sorry, my lord. And my lord, Article 3 direction is there, my lord. They file affidavit, my lord.
So we'll have the affidavit. You want to file a reply to that?
No, this is the 1 part and 3 part directions are there. And below that, my lord. Therefore, it is respondent to 1 and respondent 4 have to place on record decision taken to the aspect of the Kilakili part and Betoli part pond, which are claimed to be part of Bolahi fishery. It is respondent number 2 that this who has apprised this court in regard to remaining two parts. In so and so remove the alleged encroachment said to it. Therefore, the steps taken by respondent.
Yes, you are for respond number 2.
Yes, Lordship.
Yes,
File affidavit.
Yes,
the government has filed an affidavit
Government file this.
and you have to file.
Yes.
Yes, Lordship.
When?
Sir, Lordship, give us 2 weeks of time.
Now give me a date.
June 15th, Lordship.
Hmm?
June 15th,
15th you will, 15th.
150.
Okay, by 15th you will file.
Yes.
Okay, if you don't file, anyway, it is rainy season, your managing director may not be having much of work now. He'll be here with the records on 17. Right?
Right.
It is submitted that in terms of the that the respondent number 1 and 4 have filed an affidavit in the matter on 25/2024.
To 26.
This said affidavit, however, is not on record. Registry to trace and tag the said record with the said affidavit with the records of this matter. Also, the learned counsel for the respondent number 2 submits that the affidavit on behalf of the respondent number 2 would be filed on or before, without fail, on or before 15/6/2026. Also, accordingly, registry to list this matter again on 17/6/2026. In the event the affidavit on behalf of the respondent number 2 is not brought on record by 15/6/2026, on 17/6/2026, the incumbent in the post of Managing Director, Assam Fisheries Development Corporation Limited, shall remain present in person before this court along with the contemporaneous records to assist this court in disposal of the present petition. Registry to list this matter again on 17/6.
March.
Legal Lordship, can a matter when we take up after some time? My senior is on next.
Lordship, in terms of court order 3rd of December, we have filed our affidavit last week. Lordship, it is not on record.
By respondent number?
Respondent number
7.
2 and 3.
2, 3, and 4.
Yes, my lord.
But that was filed in
No, another court directed, Lordship, on 3rd of December.
that is not on record.
Yes.
The last affidavit here is 1911.
Yes, mine.
And you have filed afterwards.
Afterwards, on 21st, Lordship. 21st May.
May. In terms of which order?
3rd of December 2025, Lordship.
No, the bills are admitted.
No, here, Lordship, we have received the good after getting the documents from the petitioner. We have verified and it has been distributed amongst the district also. But only thing is that the rate that he has given in the bills, how he got that rate.
That is for you to take a call.
Lordship, there was no basis, neither, Lordship, we had initially given any NIT, nor any specific how it was done.
No, you got to fix a rate for that.
Lordship, that discussion, in my humble submission, on the both sides, Lordship, that has not been done.
So how did you receive those materials? Just in air? Who is the authority? What action have you taken against him?
Lordship, nothing, no action has been initiated till now.
Once you require something, no NIT, you might have placed an intent. A requisition was made.
Indian also was not placed.
Then how did he make the supplies?
Well, only because he got some email from the private respondents here, Lordship. On that basis, and he supplied the goods. In the email also, Lordship, no request was made.
No, supplied the goods to Assam Sarva Shiksha.
Yes, that on verification subsequently.
Why did you accept that then? Now, if you have accepted it, pay at the rate he is claiming.
Lordship, my humble submission will be that let him approach the authority. Lordship may keep the case pending. Lordship,
We are not doing anything. It's for you to, now that the goods have been supplied.
yes, Lordship,
So
that also,
that admission
we
is
have
there.
admitted in the, Lordship can peruse it. We have admitted that.
Then that is the end of the matter.
As
As far as this, now whatever dues are there, you will release it to him.
only with regard to the rates and everything, Lordship, my humble
We'll get the
submission.
affidavits on record.
Yes, Lordship.
Mr. B. Chaudhary, Learned Counsel, Standing Counsel,
Assess-
SSA, Assam, submits SSA, Assam, Assam, submits that an affidavit, additional affidavit.
It was comprehensive.
And the affidavit has been filed on behalf of the respondents number 2, 3, 4, 2, 3, and 4 on
21st May
21
2026.
5 2026. The said affidavit is not available on records. Registry to trace and tag the said affidavit along with the records of the case on the next date of listing. Also, registry to list this matter again on. You want to file an affidavit to that, madam? Reply to that?
Yes, sir.
To list the matter again after 2 weeks on a date to be fixed by it. The petitioner would be at liberty to file a rejoinder to the said affidavit filed by the respondents number 2, 3, and 4.
May please, Your Lordship.
Yes.
Kindly see the matter order. It is 4/2/2026, madam. They present maintainability of the suit.
Yes, which order?
4/2/2026, madam.
4-2.
Thanks. They have filed their affidavit, madam.
You want to file a reply? No.
He has admitted that, my lord. Madam, kindly see page number 57, my lord. The deponent stated the percentage of share held by the so-and-so 99.61, my lord. Government share is 99.61, my lord.
So
Second,
it's a government
My
cooperative
lord.
society.
No, my lord, because, my lord, next para, it is respectfully submitted that the conversion of a loan amounting of rupees 20 crores into equity shares, that was converted because it was a loan from the government, my lord. Then, my lord,
I'm sorry.
my lord.
There are decisions of this court which says that government cooperative societies
Yes.
will lie. Normal
But-
cooperative societies will not lie.
but my lord, here, my lord, the government must have the financial or administrative and functional control over the organization.
If you have 99.1% share, it's your corporation,
No, my lord,
cooperative
they-
society.
the
Directors are all yours.
administrative control, financial control.
Show me that you don't have administrative control over this. Even after 99.1
Yes, my
share.
lord, government doesn't have.
Why?
Let government say, my lord, because
Who?
it is run by,
Who are you?
Me,
You are
my lord.
appearing
Good
for
me,
whom?
my lord.
I am appearing for the mill, my lord. jute mill, my lord.
Okay.
The jute mill, my lord, is run by a duly elected management board, my lord.
Government has no representative.
Government doesn't have any function.
Then what about this 99.1% share with the government?
That share, my lord, that was a loan from the government. Subsequently, my lord, it has been converted to the equity share, my
So
lord.
that is what, once it has 99.1%,
Yes,
where
my
is
lord.
the thing gone?
My
I don't
lord.
understand. Maybe it's going bouncers for me. I don't understand your submission. What is it?
But my lord, while running the
I understand a cooperative society
for instance, my lord,
operating
now,
in a manner.
now at present, my lord, for instance, let me submit, my lord, at present, my lord, the operation of the mill has been suspended for an indefinite period. Because, my lord, now they are financially, due to financial crisis or the lack of raw materials or some other thing. But government is not doing anything to recover it, my lord.
We'll come to it. Now tell me only that
Yes, my
whether
lord.
the government is having 99.1% share in the cooperative society.
Yes, my lord.
The government thing.
But, my lord, there are certain judgments of the Supreme Court
Mr.
itself.
Dotto was here somewhere. Just so. Mr. Dotto, if a cooperative society has 99.1% share government, will it be a cooperative society, that private thing, or a government cooperative society?
Absolutely not.
But, my lord, this Supreme Court judgment also says that, my lord, only having the share or the fund is not sufficient, my lord. It must show that, my lord, the body is financially.
Pradip Kumar Biswas.
Yes, my lord. Financially, functionally, and administratively.
Show me decision. This is not accepted. Show me that a cooperative society which the government
my lord.
has.
I'm not saying that a cooperative society is not a state, my lord, but the particular cooperative society, my lord, which is running independently, my lord, by a managing committee, duly elected managing board, my lord, management.
Be that as it may,
Yes, my lord.
once it is a government cooperative society,
Let government says it, my lord.
Kindly see that.
Let the government file an affidavit, my lord.
My lord.
My lord, let government file an affidavit to that effect, my lord. If the government says so, then I don't have any submission to make, my lord.
Page number 7, paragraph 3, my lord.
If the government says that it is a government organization, my lord, then I don't have any to say.
okay. But the Learned Council for the parties at some length registered to list this matter again on. Not right here, give us 9/6/2025 for further hearing.
My lord,
Will
can
also
it, be,
come prepared.
can it be on 11th, my lord?
No
9th?
problem. 11th.
My lord, in the meantime, let the government file an affidavit.
We have got your affidavit is more than enough for us. Mr. Bora filing an affidavit.
No, my lord.
Questions asked.
Let government says whether it is a government or not.
We will deduce that, interpret that.
Yes, my lord. Oblige, my lord.
Well, just check, my lord, but we have filed affidavit. We'll just check that affidavit is correct, not in the court.
Only the affidavit of the government is 226 is on record.
Yes, we have filed a reply.
Oh, you have filed a reply?
Yes, that is not in record. We have filed on Thursday last.
Okay, Mr.
Is it possible for tomorrow? Or 10th of June?
10th. Mr. B. Dr. Learned Senior Counsel appearing for the petitioner. It is submitted by the Learned Counsel for the petitioner that an affidavit in reply was filed on. It was filed on behalf of the petitioner against the affidavit in opposition filed by the respondent number 226. So, however, they said affidavit in reply is not on record. Registry is directed to list this matter again on 10/6/2026 along with the said affidavit in reply filed on behalf of the respondent. Petition.
My lord, in this case, I am to file an additional affidavit, my lord, which is ready. I'll file it today, my lord.
Miss.
Only one more
Mr. Enja.
one more prayer, my lord.
another writ petition is pending, my lord, same, my lord. Can it be, my lord, the number I'm 6758 of 24? Can be tagged, my lord. 6758/24.
24.
6,
Heard Mr. NZ or Learning Council for the petitioner. Also heard Ms. Udas, additional senior government advocate. Ms. Udas submits that additional affidavit on behalf of the respondent corporation, respondent authorities, state respondents is being filed during the course of the course of. Mr. Dotto submits that matter submits that another writ petition involving similar issues is pending before this court and prays that the same be also tagged along with the present writ petition on the next date of listing. Also, I accepted a registry to list this matter again on 12/6/2026 along with WPC number 6758/2024. Also, the parties to complete their pleadings before the next day. If they file an additional, if you want to file a reply, do it before the next date of listing.
I'm obliged.
Obliged.
Please, your lordship. The matter is regarding non-payment of contractor's bill. Non-payment of contractor's bill.
What is there admission?
Yes, lordship. They have filed their affidavit, lordship. Respondent number 3, page 42 of their affidavit. Paragraph 6.
That much only, 21, 23, 91, 253.
253.
That much will direct to be paid. Dispose of. Mr. Bean. A common order, similar order.
Time frame, your lordship.
Time frame. If they don't pay within that time frame, should I put interest or contempt? Or you want to file a contempt?
No.
Which is more beneficial?
If not paid.
Okay, I'll put it. Time frame 3 months. Will not say anything further. Because if I put interest, you will not get contempt.
As per temporarily case, my lord. The amount may be payable as per temporarily case, my lord.
No, not temporarily. You all take work. If you don't have money, don't do work. That's why these poor people have to be. Once you have admitted to a certain amount, that you will have to pay immediately. We'll give a time frame. 3 months.
The fund is not available at
Okay,
my lord.
6 months. Because now budget will come.
Yes, my lord.
I categorically admitted the petitioner's daughter is getting married, lordship, in the month of December, lordship.
December.
December it is.
I have categorically admitted.
May,
8
right?
months
June,
remaining.
July, August, September, October, November, December. 6 months.
6 months, your honor. Deeply obliged.
Much obliged.
There is 8 months. I'm only giving 6 months.
Lordship.
Why you file contempt then? Yes.
My lord, the chief executive officer was made party, my lord. Thereafter, we have received some instruction. I want to file affidavit, my lord. Because the work was of, my lord, from 1999, and that was to the DRDA.
Mr. S. Dr. Learned Council appearing for
Panchayat and Rural Development.
Learned Standing Council, Panchayat and Rural Development Department submits that he be granted further 2 weeks' time to file an affidavit on behalf of the respondent number 9
Newly implemented, my lord.
Chief Executive
Yes,
Officer.
yes, my lord.
on the behalf of the respondent number 9. I think an affidavit on behalf of respondent number 3 is already
Yes, yes.
okay.
We have
On
filed.
respondent. Prayer accepted. Registry to list this matter after 3 weeks on a date to be fixed. Duta 3 go iti pani.
Hello, bless.
Totally.
Yes,
Mr. Dekha.
These similarly situated cases were came up for consider on Friday, and that was disposed of, Lordship, last Friday. And disposed of, but the order is not uploaded, Lordship.
On the prayer of Mr. A. Dekha, Learned Council for the petitioner, registry to list this matter again on
Similar matter is fixed on 5th of June.
on 5/6/2026.
May I give you a number, Lordship, that 5th of June, Lord. Deep level, Lordship.
Thank you, Your Lordship. Lordship, this petition was filed with regard to the change of premises of the IMFL off shop. My lord, there are two IAs also connected in this matter. One is filed by me, that is for impleadment of necessary parties, my lord. And then they have also come up with an IA, for which we'll be filing an objection, lord.
Affidavits have been filed, no?
No, lord, he's not impleaded yet. It's the excise department and the North Gauhati municipal department that they have to come up with. Affidavits have not been filed, but we are running our shop there so far. The excise department has given us all the necessary permissions to do so. But in the meanwhile, the North Municipal Corporation of Gauhati has cancelled our NOC. But my lord, what I have recently been instructed by the clients, that had again been approved. And we have again got the NOC to operate. It was
Now,
all
this application IAC
yes, my lord.
468. This is for what?
This is for impleadment of parties. My lord, on the last occasion, what has happened, since municipal board was not a party, and there were some miscreants that were creating a problem for me running the shop. So I've given FIRs to the police station, but those were not taken into action. So the necessary party for making the superintendent of police was also directed to me. So according to that, I have made the police also a party and the North Municipal Corporation Board also a party.
Oh, you want that superintendent police, officer in charge, not Gauhati Municipal Board, Vice President Chairman, not the Chairman, so and so.
Yes, madam.
These 4.
This 4 will be confirmed 5.
And you are appearing for?
I'm for a private restaurant. I am the complainant, my lord. As per them, I am the miscreant, my lord. And
You have also filed an impleading application.
yes, my lord. And then they
Yes,
have,
my lord, I'll be filing my formal objection.
they have,
Okay.
my lord, kindly listen, my lord. Paragraph 5 and 6 of their writ petition, my lord. They have categorically, my lord,
Okay.
Until
We'll consider both the IAs together.
Lordship.
Because the complaint led to, the
Filing.
action led to your complaint,
Yes, ma'am.
right? So the authorities before the complaint, whom the complaint is pending, have not acted. So you want to bring them. So automatically the complainant also comes in.
My lord, may permit me to file my objection of this matter.
IAC 1600/2026, huh? Huh?
1604.
This is it. Asana, Mr. J. Singh, Learned Counsel for the opposite party, praised, opposite party oblique petitioner, praised that he be granted 2 weeks' time?
2 weeks' time, my lord.
2 weeks' time to file an objection to the prayer made in the present interlocutory application for impleading the applicants therein as respondents in the connected writ petition being WPC number 120/2026. Prayer accepted. Registry to list this matter after 2 weeks, along with the pending, along with the writ petition, connected writ petition and other pending interlocutory applications.
Obliged.
obliged.
So in this case, we have received our instruction, Lordship. We would like to file our affidavit.
On the prayer of the learned counsel for the state respondents. Registry to list this matter again after 2 weeks, 3 weeks. And if to facilitate filing of filing of an affidavit by the state respondents. So accordingly, registry to list this matter again after on the prayer of the so and so, adjournment 3 weeks after 3 weeks. Yes, Mr.
Yes.
Das.
We'll file affidavit, my lord, affidavit in opposition.
None appears for the petitioner on call. Mr. S. Das, learned counsel, appearing for respondents. You are appearing
For the respondent, my lord.
respondent number?
Respondent number 1.
1.
Item 1.
That he be granted further. For the sole respondent, submits that he be granted further. How much time you want?
3 weeks time, my lord.
Submit that he be granted 3 weeks time to file affidavit, file a response. File a response in the matter. Full stop. Prayer accepted. Registry to list this matter again. After 2 weeks for admissions. 3 weeks for admission.
Obliged.
But for none appears for the petitioner on call. For the ends of justice, registry to list this matter after 2 weeks until to get expired.
Your Lordship, I'm appearing on behalf of P. Nayak, sir. Item number 26, Your Lordship.
26 adjourned. 28.
May I please?
You're
Release made herein, your lordship, is the your lordship order dated 1/9 your lordship 2026 your lordship, whereby your lordship the trade license of the petitioner is cancelled your lordship. Lordship will find your
No affidavit has been filed.
no affidavit.
Yes.
For respondent number 5, I'll be filing my affidavit in the course of the day.
Okay.
Lordship, I am appearing for the respondent number 2, 3, and 4.
The learned counsel for the respondents have
26
submitted that an affidavit on
I am
behalf.
praying 2 weeks time for filing affidavit.
An affidavit would be filed within a period of 2 weeks from today. So, no further adjournment shall be granted in the matter. Accordingly, registry to list this matter immediately on conclusion of 2 weeks from today. Mr. Bhumik, you bring it on record, there is no problem. But I've given you 2 weeks as a last chance.
Lordship, my name is not reflected in the cause
course
list.
of the day.
Lordship, my direct.
Please do so, Mr. Bhumik. You are appearing for?
Respondent number 5.
Mr. P. Bhumik, learned counsel, appearing for the respondent number 5, submits that the affidavit on behalf of the respondents represented by him would be filed during the course of the day. Mr. H.K. Sharma, Mr. H.K. Sharma, learned counsel, appearing for the respondent number 2, 3, and 4.
Johat Municipal Board.
Joratma, praise that he be granted further 2 weeks time to file an affidavit. Prayer accepted. Registry to list this matter again. On 12/6/2026.
Obliged,
No further adjournment shall be granted for the respondents to file an affidavit in the matter.
My name, my name is not shown.
Registry to list this matter on so and so, reflecting the name of Mr. H.K. Sharma for the respondents number 2, 3, and 4.
Lordship.
My lord, I am sorry, my lord, I have missed my item number 26, my lord. My name may kindly be recorded, my lord, for the petitioner, my lord.
Oh.
My lord, I am online, my lord, that's why I missed the item.
26 to enega likha, karu naam na lage. On the prayer of the learned counsel for the parties, registry to list this matter again after 2 weeks.
2 weeks, my lord. Obliged, my lord. Sorry, my lord.
Today, no dismissal for default.
My lord.
Lordship, the engaged senior counsel Mr. DP Bora is on lake in court number 22. So the item may be passed over for the timing, Lordship.
Lordship, same, my senior is at Lex.
On the prayer of the learned counsel for the parties, the registry to list this matter again. On. You don't want to file and reply? This will have to have some hearing done. Okay.
Your Lordship, may this matter be passed at 2 p.m.
They are not possible. On Ajikiman process now. On 4/6/2026.
Lordship, may I please, Lordship? In item number 28, there is just interim order, Your Lordship.
28. Interim order passed earlier to continue till the next date of it. 28, na?
28, Lordship.
My lord, item 33, 34, and 37, these are similar matters. My lord, needs further 3 weeks time.
Item number?
33, 34, and 37.
33, 34, 37.
Yes, but
In 33.
Same issue.
Same issue.
same issue.
Oh,
In 33, my name has not been shown. That's why I was 33.
33, your name?
My friend's name is Zayab.
Okay. 33, 34, 35.
37.
37. Not 35.
Not 30.
Not 35.
33, 34,
34 and 37.
33 and?
33, 34,
And
and
37.
37.
On the prayer of Mr. S. Dr. Learned Standing Council, Public, Panchayat and Rural Development, registry to list this matter again after 2 weeks to facilitate filing of an affidavit by the for filing affidavits in the matter. Full stop. Mr. S. Dr. Learned Standing Council, Panchayat and Rural Development Department prays that he be granted further 2 weeks time. 3 weeks time.
3 weeks.
File an affidavit in the matter. Prayer accepted. Registry to list this matter after 3 weeks on a date to be fixed by. Because their affidavit would be required.
My lord.
33, 34,
34 and 37.
Obliged.
Highly obliged.
Lordship, in this case, I need some further time to obtain our instruction, Lordship.
In the prayer of Mr. Burwa, Learned Counsel for the Senate Government Advocate, matter be listed after 3 weeks. Mr. Burwa shall before the on or before the next date of listing file an affidavit in the matter on behalf of the respondents represented by him.
Obliged, Lordship.
Non-appears for the parties on call. For the ends of justice, registry to discuss matter again after 2 weeks on a date to be fixed by.
I'm for a 36. Don't be built up my contact or village.
On the Mr.
D. Gogol.
D. Gogol, Learned Counsel for the petitioner. Non-appears for the respondents.
No, Lordship, I'm Deputy Commissioner.
No. PWD bill.
PWD. You're not PWD, are you?
Yes.
Non-appears for the ends of justice, registry to list this matter again after 2 weeks. None appears for the parties on call. For the ends of justice, registry to list again after 2 weeks.
39.
Yes, Mr. Deka.
Lordship, 38 was mine.
My lord, my item is 39.
Mr. D. Dole, huh?
Lordship, at to Lordship, he is not present, respondent. Otherwise, Lordship, admitted amount, contractual bill.
Funny, definitely.
Admitted amount, Lordship, he more state me that morning.
39.
38, Lordship.
38 irrigation.
Irrigation, Lordship.
They have filed an affidavit.
No, but he received the instruction.
No, that will not do. They'll have to file an affidavit. Ask him to file an affidavit. We'll consider this matter next week itself. An affidavit is required, Mr. Dole. How will it be otherwise? Huh? But Mr. D. Dole, learned counsel for the petitioner. There is no representation on behalf of the respondents. Accordingly, registry to list the again on.
So that may be.
Mr. Upadhyay.
Lordship, this is regarding non-payment of.
Where is your affidavit?
Lordship, I have received my instruction. The crux of the instruction is that, Lordship, it is admitted due, Lordship.
File a small affidavit by tomorrow.
By tomorrow, Lordship.
Day after tomorrow.
Next week, Lordship.
Registry to list this matter again on 1/6/2026. Mr. Upadhyay shall invariably bring on record the stand of the respondents represented by him by way of filing an affidavit on or before 1/6/2026.
Oblige,
We have filed an affidavit today. We have that copy. But it has not come on record. We tried.
Mr. S.K. Das, counsel for the
Friday.
submits that.
Friday.
An additional affidavit. Affidavit for what?
Reply also to their rejoinder.
An affidavit in reply has been filed to the affidavit filed by the respondent number 1. You are for the respondent number 1.
Yes.
Opposite party one. Opposite party number 1.
Opposite party number 1. Registry to list this matter again. Opposite party?
My lord, this is IA.
In IA also.
I'm the petitioner otherwise.
39.
49 indicator.
Is it
I'm appearing in 39.
Is it 39?
Yes, Mr. Deka.
My lord, my drag license has been cancelled without affording me any opportunity of hearing, my lord.
Yes, madam.
We have filed our affidavit, Lordship. Can
You want to file a reply to this affidavit?
Lordship.
My lord, we have filed our reply on Friday. Might not be in the
It
record.
is submitted by Mr. B. Deka that a reply B. Deka Lana counsel for the petitioner that a rejoinder has already been filed by the petitioner to the affidavit filed by the respondent number 1. However, the same is not on record. A registry to list this matter again on 3/6/2026 along with the said affidavit in reply filed by the petitioner. We'll take it up on 3rd.
Much obliged, my lord. Much obliged.
Lordship, I'm selling a transfer order to CRPF, my lord.
My lord, I have not heard the item number, my lord. Is it 40 or 39?
This is
51.
51.
My lord, my item was 40, my lord.
It'll come. It'll come. Wait for 2 minutes. This is supplementary list admission.
My lord. Actually, court master mic is not working, I suppose. That is why I have not heard the calling.
This is all, we are starting with a new phase, Mr. Somua. Everything cannot be perfect in one day.
Well,
it'll be slowly perfected. Right?
Right.
So, my lords, I'm posted right now at Silchar. I'm being transferred out to Jharkhand. My lords, in the year 2025.
Now, after 15/5, what happened?
My lords?
15/5/26, you have been released.
No, not released, my lords. This case is there. There's no interim, my lords, but I have not been released because.
So, who is for the respondent?
I'll try to bring one
up today. Mr. D. Gugui, learned counsel for the petitioner. There is no representation on behalf of the respondents. So, for the ends of justice, registry to list this matter again on 29/5/2026. Oh, 29 Aku online over nalage. On
will come, my lords.
On 27. 27/5/2026. Yamata.
27 of this.
This is my 27.
Hmm.
40 lordship, matter may be listed on lordship 27 or 29 lordship, 28 lordship, along with the affidavit.
Yes, Mr. Somo, your matter.
My lord, we have yet to file the affidavit, my lord.
Hmm. Hmm. Who is for the petitioner, Mr. Das?
No, lordship petitioner.
Petitioner is here. Be woke. I heard this matter.
Yes,
no?
Lordship granted the petitioner to file a rejoinder affidavit.
Hmm.
I have filed, lordship.
And what is this IA for?
I have for lordship vacating the interim order also.
Okay. So this IA, you have filed, they have filed objection. And thereafter, you have filed a reply rejoinder.
So I was directed to file an additional affidavit to bring on record lordship the attendance sheet lordship that I have done. Then he have filed again the rejoinder affidavit. To that lordship I have filed my reply. Today.
Okay. So that is the end of the matter.
That is the end.
Mr. SK Das, Learned Counsel, Learned Counsel appearing for the opposite party number. Oh no, Learned Counsel appearing for the applicant has submitted that affidavit has been filed in response to, by the applicant in response to the rejoinder affidavit filed by the opposite party number 1. However, the same is not on record. Registry to list this matter again on
Friday lordship.
Yeah, Friday more difficulties.
2/6/2026, along with the said affidavit filed by the opposite, by the Learned Counsel for the applicant. Also, on that day, we will take it up for finals.
Obliged.
Yeah, get it.
My lord, we record our presence, my lord.
लिखी दी पहला सौ डाटा से तो लोग ऐसे.
Obliged.
May I please, lordship? I'm appearing for on behalf of senior advocate Ms. B. Bhuya for BTC. Lordship, can the matter be taken up on another day to obtain further instruction?
Wait.
To obtain further instruction, lordship.
None appears for the petitioner. For the ends of justice, registry to list this matter again on 10/6/2026.
Obliged, lordship.
May I please? My lord, here respondent number 7 has filed affidavit in my lord, opposition. I need short time to file counter on that.
What about your steps on 10, 11, and 12? You have not taken steps.
Your lordship, I'm appearing for respondent number 11.
11.
Yes,
10,
lordship.
10, 10.
Channel.
You have not taken steps for respond number 10, Mr. Mandal.
I'll take for a step, though it was taken.
Seen the office note dated 25/2026, which reveals that the petitioner has not taken steps for service of notice upon the respond number 10. The Learned Counsel for the petitioner submits that he would take the steps in take steps for service of notice upon respond number 10 by tomorrow.
By register, my lord, as well as my lord, Dasti.
Prayer accepted. Registry to list this matter again after 4 weeks on a date to be fixed by. In the meantime, the respondents appearing in the matter are at liberty to bring on record their respective stands by way of filing affidavits.
Yes.
Lordship, item number 3, Lordship, I am appearing, my lord. Item number 3, my lord.
But your senior counsel is not here. So 2 o'clock.
Lordship, my lord.
Yes. None appears for the parties. For the ends of justice, registry to list this matter again after 2 weeks on a date to be fixed by. Avoid idiot. Next.
So
That was it.
Lordship may take up 51 at second half, Lordship. I was in the ground floor, so.
No problem. Yes. No, not today.
With resolution. Well, in this case, my lord, I was directed to take steps on the newly implemented respondent number 5 and 6, my lord, for registered post, my lord, as well as my lord trustee, my lord.
Why? Steps not taken?
My lord, both were taken, my lord. Only my trustee service, my lord, in respect of respondent number 5 was taken.
But here.
Yes, my lord, I did not file the affidavit, my lord, on that effect, on trustee service, but the speed post, my lord, remarks is there, my lord, it has already been delivered, my lord.
So you have delivered by, you have also served by Dusty.
Dusty in respect of respondent 5 was served, my lord. Only remaining respondent 6 is remaining, my lord.
Send the office note dated 21/5/2026, which reveals that you are appearing.
Your Honor, I am marking my appearance on behalf of respondent number 6.
6, okay.
I will file my wakalatnama shortly. They are situated at Udalguri, and I'll require some time to file my affidavit.
In the office note dated 21/5/2026, which reveals that the notices issued by way of speed post upon the respondent number 5 and 6 have been served on the said respondents, have been delivered to the said respondents. Accordingly, service of notice upon respondent number 5 and 6 is held to be complete. Mr. N. Surana has entered appearance.
On behalf of respondent number 6, Ashok Kumar Bajaj.
Appearance on behalf of respondent number 6 and prays that he be granted further 3 weeks time.
Only
Lord, for the convenience of the court.
Tender, my lord, tender matter, my lord.
3 weeks time to file an affidavit in the matter. Also, the other respondents are also directed to file their respective affidavits before the next reasonable date. Also, registry to list this matter again after 3 weeks on a date to be fixed by it.
I have been informed that work has already been allotted, my lord. So, my lord, if long date is given, my lord, the work will.
2 weeks, 2 weeks going.
Let it may kindly fix, my lord.
2 weeks.
Tender matter, my lord. So, get it.
We can consider it today only. Signature part.
Yes.
Yes, my lord. That part, yes, my lord.
1. 10 तारीख है दीदी.
Lordship.
No obligation.
No obligation.
Mr. Surana, you bring your affidavit.
Lordship, I'll bring everything on record, Lordship. Very much obliged.
Yes, Mr. Singh.
My lord, matter pertains to unpaid bills, my lord.
Huh?
Unpaid bills, my lord, matter pertains to. So.
No affidavit.
No affidavit, my lord, and also the office note indicates that proof of service has not been given. But copies were given, and on that date also all the advocates were present, my lord, in the court. If my lord will peruse order it 7/4/2026. Only extra copies were something that was required to be given, and I have given that in the due course. RRGOG stands for Forest 1 and 3. STEM Chitia stands for Respondent 2.
And who is there for 5?
PGC for finance, my lord, there is no one has come on that date, but a copy was given to the finance department.
Finance department. This has come for orders now.
Yes.
It is seen that all the respondents are represented in the matter. Accordingly, the registry to list this matter again on 17/6/2026. The respondents in the meanwhile shall invariably bring on record their stand by way of filing affidavits.
Call your question.
Yeah. Yes, Mr.
Here, the admissible amount, my lord. But earlier it was Honorable Court's order, my lord, case 13. Relevant question 15, my lord.
Where is the admission in the affidavit?
In the writ petition, my lord, they have.
No, affidavit filed.
Affidavit filed by respondent number 2, my lord. That is paragraph 5 and 7, my lord.
But they say this is a non-permissible. There is no clear admission.
My lord, clear affidavit by respondent number 2, my lord. That is the Dibakar Nath.
Page?
Page, my lord, 26. Running page. Paragraph 5. The district commissioner, the deputy commissioner come chairman of district program coordinator. He is the relevant person, my lord. Direction was given to him to verify and pay. Now the commissioner PNRD is saying that not permissible. He was not, direction was not given to him, my lord. Direction was
Now, have they passed any order after verification?
After verification, they have issued a letter, my lord.
Where is that?
In my lord, in my petition also, contempt petition.
Page?
Page 22.
Yes, who is appearing for respondent number 2? That is the deputy commissioner. Let's file this affidavit.
My friend Zain Henry was.
Item number, Kiman? 52. Jay Handy. Mr. M.R. Khandakar, Learned Counsel for the petitioner. There is no representation on behalf of the respondents. So, for the ends of justice, a registry to list this matter again on 2/6/2026. We'll see on that day.
2/6.
Because maybe online today they are not here.
Today on 3rd, my lord.
3/6. Okay, now.
Timely.
Yeah, please, as I instructed now, the petitioner has already got the relief, my lord, in this case.
Respondent number 7 has filed the writ petition. So in that case, isn't it? Dismissed, not dismissed, but order has been passed. 11/3/2026 order has been passed, distributing the my lord fair price shops material to all the societies. So that's why they have already. Lordship may be pleased to peruse the order if your lordship, my lord. I have received the instruction. That's why they got the relief.
Yes, what happened? You got your relief?
Yes, my.
Yes, yes.
Mr.
This
T.
is-
Sheikh,
Later, your lordship, by which they got the claimant.
learned counsel, when he's saying what
One.
learned counsel for the petition has submitted that. You want to withdraw it or close it as infraction? Submits that during the pendency of the present petition, the petitioners herein have been granted the relief so prayed for in the present proceedings. They said submission is not opposed to by Ms. Udas Learned, additional senior government advocate appearing for the state respondent. Also, in view of the said submission made by the learned counsel for the petitioner, the present petition stands closed on having become infructuous.
Last.
So, Chaudhary, you are appearing for the second case. So, Chaudhary, we have gone through. This file was not with me yesterday, so I could not. Now I have done it. Now, you're that first 16/5, 2008.
Yes.
That we are not interfering because therein, they say because of negligence, there was a charge against you and negligence, and 2008 order, you have only challenged in 2025. So that thing we are not coming in.
2 increments.
Now, the second part with regard to your penalty of dismissal from service, rightly so, because it was in pursuance to a conviction. Now, that order continued only till the passing of the appellate order, by the appellate court on 21/5/2025. When did you retire?
I retired on 30/6/2017.
So, now how do we put you back? Because you were terminated in 2011.
Lordship.
And this order came subsequently, after your retirement.
The page 83 order.
Hmm.
Page 83 order. May I read?
No, this will go.
Lordship.
This has to go. But I'm more concerned with how to regulate that period of yours. 11 to 16.
To 16.
Because you retired in the meantime.
Lordship.
We'll give you notional benefit for the whole period. Pension and pensionary benefits, they will accordingly calculate. And secondly, with regard to your 16.5, even if I say that there is delay, I condone the delay. There is no material. There is no charge sheet. There is no inquiry report. There is nothing.
He has also lost all those things.
Nothing is on record and no statements that why it is bad. Nothing. Okay. Shall I put your name or Mr. Chakraborty's name? His name.
Anyone?
D. Chaudhary, Learned Counsel for the petitioner. I'll pass 2 orders. In your case, subsequently, first let me pass an order in his case. Just if I miss out on any facts, just let me know. You take your seat. Also heard Mr. Who had appeared? Mr. D. Bora. D. Bora, Government Advocate. Mr. D. Bora, Learned Government Advocate for the respondents number 1, 2, 3, 4, and 4. Also heard Mr. Who is there for finance today? Mr. A. Cholia, Learned Standing Counsel, Finance Department, appearing for the respondent number 5. And Miss R. Datta, Learned Counsel, appearing, Miss R. Datta, Learned Counsel, appearing on behalf of Mr. S.K. Medi, Learned Standing Counsel, AG, for the respondent number 6. The petitioner, by way of instituting the present writ petition, has prayed for, has assailed an order dated 18/8/2025, issued by the respondent number 3, imposing a penalty of dismissal from service upon the petitioner has assailed an order dated, has assailed an order dated 18/8/2025, rejecting the prayer of the petitioner for reinstatement in his service by interfering with the order of penalty of dismissal from service imposed upon him by the order dated 27/5/2011. The petitioner has also presented a challenge to the orders dated 27/5, to the order dated 27, to the said order dated 27/5/2011, along with a challenge to an order dated 16/5/2018, 8, passed in the departmental proceedings instituted against him, imposing upon him a penalty of withholding of 2 increments with cumulative effect. The petitioner has further prayed for regularization of his period of absence on account of imposition of the penalty of dismissal with effect from 27/5/2011 to 30/6/2017. Also, the facts in brief requisite for adjudication of the issue arising in the present writ petition is noticed as under. On 25/8/1994, while the petitioner was working as a traffic constable in Morioni Police Station under Jorhat district, one Soriful Hussain was taken into custody by Moriani police in connection with a theft case. Also, on the next date, that is on 26/8/1994, said Shariful Hussain was taken by the police personnel for search and recovery of the stolen scooter. Also, it is projected that Shariful Hussain, however, died in custody and his dead body was recovered from a pond and a case of unnatural death was registered. Also, an inquiry was thereafter held in the matter, and on the basis of the materials coming on record in the said inquiry, an FIR came to be lodged against the petitioner on 18/2/1995, alleging therein that the death of the victim was caused on account of the negligence on the part of the petitioner herein. The said FIR was registered as Moriani PS case number 17/1995. Also, on conclusion of the investigation in the matter, the police laid a charge sheet against the petitioner under section 302 IPC. Also, the case on being committed to the Court of Session Judge, they said the same was registered as Sessions case number 93 bracket JJ bracket over oblique 2000. Also, the learned trial court framed a charge under section 302 against the petitioner herein. Thereafter, the trial ensued, and on conclusion of the trial, the learned trial court, while ordered it at 16/5/2008, proceeded to convict the petitioner herein. Oh, no, sorry. Also, no, in the meanwhile, the departmental proceeding was instituted against the petitioner, being BP case number 14/20/1994. So, on conclusion of the said proceeding, the disciplinary authority of the petitioner, while ordered it at 16/5/2008, proceeded to impose a penalty of withholding of 2 increments with cumulative effect on the petitioner. Also, the said departmental proceeding was so instituted basing on the allegations which were leveled against the petitioner in the criminal proceedings instituted against him. Also, the learned trial court thereafter, trial ensued on conclusion of the trial, proceeded by judgment dated 30/4/2011 to convict the petitioner herein under section 304 part bracket Roman 2 bracket over IPC and sentenced him to undergo rigorous imprisonment for 5 years along with payment of fine of rupees 5,000, in default to undergo further simple imprisonment for 6 months. 304 part 2 IPC 304 part 2 oblique 201 IPC, and to undergo rigorous imprisonment for 2 years for the offense under 304 part 2, and to further to undergo rigorous imprisonment for 2 years along with fine of rupees 1,000, in default to undergo further simple imprisonment for 1 month for the offense under section 201. Also, the conviction of the petitioner having come to the knowledge of the disciplinary authority of the petitioner, the disciplinary authority proceeded while order dated 27/5/2011 to impose upon the petitioner a penalty of dismissal from service with effect from 2/5/2011. Also, the said penalty as imposed upon the petitioner was so imposed basing on the conviction of the petitioner by the learned trial court. Also, The petitioner, thereafter, the petitioner being aggrieved by this judgment, by his conviction and sentencing by the learned trial court, assailed the same before this court by way of filing an appeal, being criminal appeal number 98 of 2011. Also, this court-wide order dated 21/5/2025 proceeded to dispose of the said appeal by interfering with the conviction and sentencing of the petitioner, so affected by judgment and order dated 30/4/2011 passed by the learned trial court in sessions case number 93 (JJ) /2000. The petitioner accordingly was acquitted from the criminal charges framed against him. Also, the petitioner, during the pendency of the criminal appeal before this court, had attained the age of superannuation with effect from 30/6/2017. Also, the petitioner thereafter approached his disciplinary authority, praying for his reinstatement in service, basing on his acquittal from the criminal charges framed against him in terms of the judgment and order dated 21/5/2025 passed by this court in criminal appeal number 98 of 2011. Also, the petitioner also approached his appellate authority with the same prayer. The appellate authority, by order dated 18/8/2025, considered the appeal preferred by the petitioner against his against the imposition of the order of penalty upon him, and proceeded to reject the said appeal, affirming the penalty of dismissal imposed upon the petitioner herein. Also, that much facts have come. Yes. Mr. D. Chaudhary, learned counsel for the petitioner, by reiterating the facts as noticed herein above, has submitted that the penalty of dismissal from service as imposed upon the petitioner, while the order dated 27/5/2011 was not so imposed after holding a full-fledged disciplinary inquiry, in the matter against the petitioner. He submits that the said order was solely based on the conviction of the petitioner by the learned trial court in sessions case number 93 (JJ) /2000. He submits that the said conviction and sentencing of the petitioner, having been interfered by this court, while judgment and order dated 21/5/2025 in criminal appeal number 98/2011, the very basis for imposition of the penalty of dismissal from service upon the petitioner having been removed, the order dated so-and-so, order dated 27/5/2011 cannot be held to be sustaining, and the same would mandate to be interfered with. Mr. Chaudhary has further submitted that immediately after the passing of the said judgment and order dated so-and-so, 21/5/2025 by this court in criminal appeal number so-and-so, he had approached the respondent authorities, praying for release to him his pension and pensionary benefits by revoking the order of dismiss order of the penalty order of imposition of penalty of dismissal from service upon him. Mr. Chaudhary, by referring to the order dated 18/8/2025 next year, passed by the appellate authority, has submitted that the appellate authority, after appreciating the materials coming on record, had proceeded to reject the claim of the petitioner only on the ground that while this court, while they said order dated 21/5/2025, only on the ground that this court, while order dated so and so, while interfering with the judgment and order dated so and so passed by the learned trial court 30/4/2020 in 2011 passed by the learned trial court, had not made any stipulation with regard to the service benefits required to be authorized to the petitioner upon his acquittal from the criminal charges framed against him. Mr. Chaudhary submits that it is not for the criminal court considering the appeal preferred by the petitioner against his conviction and sentencing by the learned trial court to pass orders also touching upon the service benefits receivable by the petitioner pursuant to his such acquittal. Mr. Chaudhary submits that the petitioner, having been acquitted from the criminal charges framed against him and his order of conviction and sentencing having been interfered with, the very basis for the imposition of the penalty of dismissal from service upon the petitioner, while the order dated 27/5/2011 having been removed, the order dated 27/5/2011 cannot be held to be subsisting in the matter. Accordingly, the petitioner would be required to be deemed to be in service with effect from 2/5/2011 till 30/6/2017. That is the date he had proceeded on. He would have proceeded on superannuation on. He would have retired from his services on reaching the age of superannuation. So in the above premises, Mr. Chaudhary submits that the orders impugned in the present writ petition would mandate an interference from this court, and the petitioner be directed to have continued in his services with effect from 2/5/2011 to 30/6/2017 with all consequential benefits of pay and allowances along with. Also, Mr. Chaudhary further prays that the petitioner accordingly be directed to be authorized his pension and pensionary benefits. Per contra, Mr. D. Bora, Learned Counsel for the petition, for the state respondents, for the respondents number 1, 2, 3, and 4. Submits that the mere acquittal of the petitioner would not have an automatic effect of also rendering the order dated 27/5/2011 imposing upon the petitioner the penalty of dismissal from service to be not maintainable. It is submitted that the petitioner would not be entitled to any service benefits inasmuch as that this court, while the judgment and order dated 21/5/2025 passed in WPC number passed in criminal appeal number 98 of 2011, while proceeding to interfere with the conviction and sentencing of the petitioner as ordered by the learned trial court, while the judgment and order dated so and so in sessions case number so and so 25/2011 in sessions case number 93/JJ/2000 had not made any observation with regard to the service status of the petitioner after he was acquitted from the charges framed against him in the criminal proceedings, in the connected criminal proceedings. Also, Mr. Bora submits that the respondent authorities, after considering all aspects of the matter, had passed a reasoned order while the order dated 18/8/2025 and the same would not mandate an interference from this court. I have heard the learned counsel for the parties and also perused the materials available on record. The factual position noticed herein above is not in dispute. Also, after the petitioner was involved in a criminal proceeding, a departmental proceeding is also found to have been instituted against him. The said departmental proceeding was concluded with the passing of an order dated 16/5/2008, wherein the petitioner was imposed with the penalty of withholding of 2 increments with cumulative effect. A perusal of the order dated 16/5/2008 would go to reveal that the said penalty was so imposed upon the petitioner, basing on allegations which also formed the basis of the criminal proceedings, which also formed the allegations in the criminal proceedings instituted against the petitioner. However, what is to be noticed herein is that the penalty as imposed upon the petitioner was on account of the negligence on the part of the petitioner in not taking due care and caution to save the life of the prisoner, of the accused, who was in police custody. Also, the said order was passed on as of the order dated 16/5/2008 was, however, not assailed by the petitioner either by way of filing an appeal and or instituting proceedings before this court till the institution of the present writ petition. In view of the delay occasioning in instituting proceedings against the order dated 16/5/2008 and further there being no material brought on record to demonstrate the circumstances in which the petitioner was held to be guilty of negligence of charge, more particularly in absence of the show cause notice, inquiry report, etc., being also made part of the present writ petition, this court would not proceed at this stage to consider the validity of the order dated 16/5/2008. Accordingly, the order dated 16/5/2008 stands affirmed. Also, having drawn the said conclusion, this court finds that the petitioner was convicted while judgment and order dated 34/2011 by the learned trial court in sessions case number so and so 93 की बात से learned 93 की बात so and so on was convicted under section
page 21.
No, where is the
Page 81. 81. Last part, accused Ponidhar Bora and Nekibur Rahman are further sentenced to undergo.
No, that is sentencing, the conviction I'm asking. Was convicted under section 201/304 bracket part PART, dash Roman 2 bracket over, read with section 34 IPC. Thereafter, while order dated
Court order 21.
2/5/2011, the petitioner was sentenced as follows. A to A. Sentence to A2, page 81. A to A. RP short. The petitioner was further sentenced B to B. Also, the next, the petitioner, upon being convicted and sentenced by the learned trial court, the said decision having been brought to the knowledge of the disciplinary authority of the petitioner, the disciplinary authority of the petitioner, while order dated 27/5/2011, proceeded to impose upon the petitioner the penalty of dismissal from service with effect from 2/5/2011. A perusal of the said order would go to reveal that the same was solely passed basing on the conviction of the petitioner and not on the basis of any conclusions arrived at in a departmental proceedings instituted against the petitioner in the matter. The disciplinary proceedings instituted against the petitioner in the matter was already closed while the order dated 16/5/2008. Also, the petitioner, being aggrieved by his conviction and sentencing by the learned trial court, assailed the same before this court by way of instituting a appeal, being criminal appeal number 98/2011. This court, while judgment and order dated 21/5/2025, upon appreciating the materials coming on record, was pleased to set aside the judgment and order dated 34/2011 passed by the learned trial court in sessions case number 93 bracketed JJ bracket over oblique 2000. The petitioner herein was accordingly acquitted from the case along with the other co-accused. So, the petitioner on his acquittal from the criminal proceedings instituted against him approached his disciplinary authority by way of filing a representation dated 29/5/2025, praying for being authorized his pension and pensionary benefits. The said representation having not evoked any response, the petitioner approached his appellate authority by way of filing an application, a representation dated 6/6/2025. The appellate authority considered the said representation submitted by the petitioner to be an appeal against his order of dismissal. Also, on such consideration being made, the appellate authority, while order dated 18/8/2025, proceeded to draw the following conclusions. Para 5, page 93. Para 5, A to A. Basing on the said conclusions drawn, comma, the appellate authority further proceeded to hold that in terms of the rules holding the field, dismissal from service having entailed forfeiture of all consequential benefits unless otherwise directed, comma, held that this court in the order passed in the criminal appeal being silent on the restoration of service benefits to the petitioner, comma, the order of dismissal from service was affirmed. Also, the petitioner was affirmed. This court has perused the order dated 27/5/2011 and as noticed herein above, the said order was not an order passed by the disciplinary authority on conclusion of a departmental proceeding instituted against the petitioner. The said order was so issued only on basing on the conviction of the petitioner in the criminal proceedings pending against him at the relevant point of time. The conviction of the petitioner having been interfered with subsequently by this court in writ appeal number so and so, white judgment and order dated so and so, comma, the very basis for the imposition of the dismissal, imposition of the penalty of dismissal from service upon the petitioner, while the order dated 27/5/2011 stood removed. Also, although there is a delay in the petitioner approaching this court after the passing of the order dated 27/5/2011, comma, in the facts and circumstances of the present case, the said delay cannot be attributed to the petitioner inasmuch as the challenge to the said order would have been permissible only after the disposal of the appeal preferred in the matter by the petitioner against the judgment and order passed by the learned trial court convicting and sentencing him Also, the said criminal proceedings instituted against the petitioner had resulted in his acquittal only with the passing of the judgment and order dated so and so, passed by this court in criminal appeal number so and so. Accordingly, there is no delay found on the part of the petitioner in assailing the order of penalty as imposed upon him in the matter. Also, accordingly, in view of the said position, this court would now examine the order passed by the appellate authority, order dated 18/8/2025, passed by the appellate authority. The appellate authority in the said order, after noticing the various stages of various facts involved, including the proceedings instituted against the petitioner, had proceeded to reject the prayer of the petitioner for being authorized pension and pensionary benefits only on the ground that the judgment and order dated 21/5/2025 passed by this court in criminal appeal number so and so, while acquitting the petitioner from the criminal charges framed against him, had not passed any direction with regard to his service-related benefits. The said position is, as the said contention of the appellate authority is astonishing, inasmuch as the appellate authority, being a senior police officer, is expected to know about such is expected to know the parameters or the jurisdiction of a criminal court of this court while considering criminal proceedings. This court in criminal appeal number so and so was not considering the order of penalty as imposed upon the petitioner, but was only examining the validity of the judgment and order dated so and so passed by the learned trial court in so and so, convicting and sentencing the petitioner under section 201/304 part 2 bracket over IPC. It is not expected that this court, while considering a conviction and sentencing of an accused, would also be required to pass orders with regard to the service related benefits of the said accused person. The acquittal of this court by this court of the petitioner hearing from the criminal charges has the effect of this court having interfered with the judgment and order dated so and so 34/2011 in so and so, and acquitted the petitioner, the very basis for imposition of the penalty upon the petitioner stood removed with a retrospective effect, that is with effect from 27/5/2011. Accordingly, it was for the departmental authorities to examine the matter and pass appropriate orders as would be called for. The departmental authorities is found to have miserably failed to act in the matter within the known by applying known principles of law. Also, be that as it may, the conviction and sentencing of the petitioner having been interfered with, this court proceeds to set aside and quash the order dated 27/5/2011, along with the order of the appellate authority dated 18/8/2025. Also, the petitioner, as noticed here in above, the petitioner has superannuated from his services on 30/6/2017. Accordingly, there would be no, accordingly, this court would not be called upon to issue any direction upon the respondent authorities to reinstate the petitioner hearing. However, the period of the order of penalty dated order of dismissal, order of imposition of penalty, order dated 27/5/2011, imposing the penalty of dismissal from service upon the petitioner, having been interfered with, the petitioner must be held to have continued in his services till the date of his superannuation. The petitioner admittedly not having discharged his duty during the said period, the pay and allowances of the petitioner with effect from 2/5/2011 till 30/6/2017 shall now be notionally fixed by the respondent authorities. While fixing the pay and allowances of the petitioner for the said period notionally, the respondent authorities shall reckon the annual increments receivable by the petitioner, along with the revisions of pay, if any applicable during the said period. Also, the pay of the petitioner as on 30/6/2017 be accordingly computed, and the petitioner's pension and pensionary benefits be accordingly processed. Also, the said exercise be initiated initiated and concluded within a period of 3 months from the date of a receipt of a certified copy of this order. The petitioner having been now held, the effect of the above order, the petitioner now having been held to be in service till the date of his superannuation, which had occasion on 30/6/2017, pending finalization of the regular pension and pensionary benefits of the petitioner, the respondent authorities are directed to authorize to the petitioner a provisional pension with effect from 1/5/2017 till the pension and pensionary benefits of the petitioners are finally till regular pension and pensionary benefits are authorized to the petitioner. So, anything more? With the above observations and directions, the present petition stands disposed of. I'll make some corrections, add some judgments and all. Yes, you want something, you have something to argue? Because I've not heard you on the last day.
My lord, actually, I reached just after the order passed.
Okay, please. If you have something to argue, you can argue.
My lord, I have already heard about the passing of the order, my lord. I have nothing to place, my lord, here. But only thing is that my respondent number 3, here, they not respondent, my lord, he is the petitioner number 3. His order is in some.
Your order is not here.
Order is there, my lord.
No, there are only 2 orders, Noor Islam and Bhupen Bora. The third person's order is not here. Srinath Pathak, where is that order? Appellate authorities order.
There is a bit difference from this order, my lord. I am coming with that part, my lord. Page 27, my lord, Annexure 6. Actually, his petition, that appeal was not directly dismissed, but he was suggested to file an appeal before last para. However, you are hereby informed that you may appeal to the appellate authority.
He did not file any appeal.
I have not filed appeal because, my lord, he is the same authority, my lord. He is the appellate authority. He is the
Okay, you have not filed. Srinath Pathak has not filed an appeal.
Not filed. This appeal is filed, my lord. But that appeal is disposed of in this way, by this order, my lord.
This is by the senior superintendent of police.
My lord.
And the other 2 orders are by Inspector General of Police.
Actually, he is the appointed authority, my lord.
Oh, IGP is the appellate authority. Superintendent of Police is the appointing.
My lord.
Okay, we are not interfering with, in one of the cases, one of the petitioner has been, 2 petitioners have been imposed with penalty of withholding of 2 increment with cumulative effect.
My lord. And
one has been discharged.
Yes.
One has, there is no penalty.
He is Srinath Pathak, my lord.
He is Srinath Pathak.
Yes, my lord.
So Srinath Pathak, there is nothing. But the orders passed in the other 2 cases for withholding of increment in 2007 or 2008. We are not interfering with that. But your penalty dismissal will be interfered with along with the appellate order. And you are still continuing in service or retired?
No, my lord. I have already my age has.
All the 3 has retired.
Yes, my lord. Age has gone, my lord. Superannuation is already.
When are the superannuation dates?
That is not calculated, my lord. Here
When you file the petition,
this.
Oh, by the day you filed this, they were retired.
My lord.
Huh?
By that time retired.
So that date you have not given here.
Yeah, my lord. 9th day of December 2025, I filed this petition, my lord. Meantime, they all are retired, my lord.
No, they retired before filing of the case.
Yes, my lord.
Okay. Let her type this out.
My lord.
Similar order, I'll pass it.
My lord.
Dispose of it.
Obliged, my lord.
Itu kali monopet. Fix that. Yes. No, Miss Bora.
Yes, my
Yes,
lord.
Miss Bora, you can hear me now.
Lordship, yes, my lord. Is it
yes.
audible? Lordship, I have one submission only, Lordship. On 18th of 5, Lordship, the department has issued one order, Lordship. Lordship, that order I have already emailed to my Lordship email, Lordship, Honorable Court email, my lord.
On which 18.5?
18.5. Yes. I have emailed. Lordship, may kindly have a look, Lordship. So, Lordship, may kindly dispose of this matter. This letter may be kindly considered, my lord. That much I have to submit.
So Dijendranath Das's promotion was cancelled.
Cancel,
Asif
my lord.
Ahmed was promoted thereafter.
Promoted.
So from that day, so he'll be an immediate junior now. From
Immediate
that day,
junior
you
now.
have been given that benefit.
Not from 19, but from 20.
20. Because 20, the promotion has taken place. The subsequent, because 19 promotion was cancelled.
Yes. Cancel in the,
That was
yeah,
because of whatever it is, that promotion is not there.
Lordship.
So the department finds that one Asif Ahmed was promoted. Just give me that order.
Yes, my lord.
Madam, a copy will like okay.
But your lordship, on the very date when Dijendranath Das was promoted, there was a vacancy. DPC did not consider my case, but considered the case.
Yes, why did you not consider him in 2019?
Lordship, the last paragraph, my lord, may kindly have a look. At that time, his DP was going on, Lordship.
Okay.
No DP, no.
There is a DP, madam.
Who your
From your order itself.
specific instruction from my client.
You come to that, then you should have dealt with that in your writ petition. You have not dealt with that. Come to the minutes, which has been brought on record.
Yes.
Oh, sorry, it's placed before this court. Minutes. Departmental proceeding is pending against Bunin Kumar Das, Asgar Ali Ahmed, Dipjyoti Kunyog, Enforcement Inspector Bapan Kolita, Bubul Nyog, Biswajit Bhattacharjee, respectively in the gradation list. Now, madam, this Ms.
Lordship.
Bora,
My lord.
this was dropped and you considered him in 2020.
Lordship.
On 8/6/2018, there was some proceeding, but
Lordship.
that proceeding is not there when you considered him in 2020.
Lordship.
That means that is dropped.
Lordship.
So why not from that day his case was not considered? Review DPC from that day.
That because in the seniority list, Lordship.
You have brought
Right.
a record of communication from the additional secretary
Lordship.
right? Wherein by the Deputy Secretary Transport Department,
Lordship.
that if the incumbent suspension was revoked in 1998, so and so, so and so, so and so, then as to why he was not, we will say that he should be considered from 19 only. From that we can see.
Lordship may kindly consider that order 18/5/2026,
This order
the
is
last
of
paragraph.
no consequence. We are ignoring this order. We'll refer to that. Lekha.
Lordship may kindly dispose of the matter.
That is what you have been saying for the last around maybe 6 days.
Because Lordship, the last paragraph, his immediate junior.
It would be in my favor. All these DP.
This is not,
nothing.
sorry.
Yesterday I specifically talked to my client. No DP, nothing, Your Lordship. No suspension.
Madam,
Lordship.
sit down. Heard Ms. B. Bhuiya, Learned Senior Counsel, assisted by Ms. Ardas, Learned Counsel, appearing for the petitioner. Also heard Ms. M.D. Bora, Learned Standing Counsel, Transport Department, appearing for all the respondents.
All the respondents.
The petitioner herein has the petitioner, by way of instituting the present writ petition, has prayed for a direction upon the respondent authorities to promote him to the post of District Transport Officer with retrospective effect by granting notional benefit with effect from the date his juniors were so promoted. Also, the petitioner petitioner who was working as an enforcement inspector on ad hoc basis initially since the year 1991 had appeared for a recruitment against the post of enforcement inspector in a recruitment process instituted by the Assam Public Service Commission. So on conclusion of the said recruitment process, selection process, the Assam Public Service Commission, via its communication dated 26/5/1995, recommended the name of the petitioner for appointment against the post of enforcement inspector advertised. Accordingly, the petitioner was appointed on a regular basis via an order dated. When was the regular?
595.
Okay, you come to 26/5/95 at page 17. That is the select list. Also, there were a petitioner was regularized in his services. In the gradation list of enforcement inspectors published as on 11/5/2018, the name of the petitioner figures at serial number 6 thereof. So accordingly, the petitioner was within the zone of consideration for his promotion to the post of District Transport Officer.
Transport officer.
District Transport Officer in terms of the provisions of the Assam Transport Service Rules 2003. The petitioner not being considered for such promotion and his juniors being so considered and promoted, had led the petitioner to institute the present writ petition, praying for the reliefs as noticed herein above. That's it.
My lord. Page 38 is the date of regularization. It's in the chart. 26/5/95. Page 38, Your Lordship.
No, that is the date of effect. The order passed naturally thereafter. That is the date of effect.
Yes.
It's okay, fine.
Registered
This
with
date of
notification.
recommendation by APSC, my lord.
Also, during the pendency of the present writ proposal, the respondents, I've heard the Ms. B. Mia, learned senior counsel appearing for the petitioner, by reiterating the facts noticed herein above, has submitted that there was no reason existing, that there was no valid reason for depriving the petitioner of his due promotion with effect from the date his junior, Vijendra Nath Das, was so promoted, while the order dated 20/2/2019. Also, accordingly, Ms. Bhuya submits that the petitioner be granted. Accordingly, she submits that the petitioner is entitled to be so promoted to the rank of the district transport officer with effect from the date his junior was so promoted. Ms. Bhuya has further submitted that during the pendency of the present writ petition, the respondent authorities, while an order dated 21/11/2020, proceeded to promote the petitioner to the cadre of DTO under Regulation 4D of the APSC bracket Assam Public Service Commission bracket limitation and Roman and functions bracket over regulations 1951. She submits that such promotion was given retrospective effect, that is, with effect from 20/2/2019, that is the date when his immediate junior, Vijendra Nath Das, was promoted to the post of enforcement inspector for the post of DTO. Ms. Bhuya further submits that the respondent authorities, while proceeding to regularize the 4D promotion of the petitioner, committed an illegality in regularizing such promotion with effect from the date the petitioner had assumed charge of the post of DTO in pursuance to the order dated 21/11/2020. She submits that the regularization, while the order dated 21/11, while the order dated 12/6/2024, while regularizing the services of the promotion of the petitioner, the retrospective effect already granted to the petitioner while promoting him initially against the said post was ignored, and the petitioner's promotion was made prospective with effect from 21/11/2020. Also, Ms. Das submits that the reasons assigned by the respondent authorities for not regularizing the promotion of the petitioner with effect from
20/0/2019. 20/0/2019, my lord.
20/02/2019 is clearly unsustainable, and the petitioner is entitled to have his services regularized, promotion against the post of district transport officer regularized with effect from 20/2/2019. Next. Per contra, Ms. M.D. Bora, learned standing counsel, Transport Department, appearing for the respondents, submits that although the petition was while order dated 21/11/2020 required to be 2020 promoted to the post of DTO with retrospective effect, that is with effect from 20/2/2019, by maintaining parity with the promotion granted to his junior, Vijendra Nath Das, subsequently it was found that Vijendra Nath Das was not entitled to be so promoted to the post of DTO with effect from 20 to 19, inasmuch as on the date he was so considered for promotion, he had already crossed the age of superannuation. Also, Ms. Bora submits that while an order dated 5/1/2026, the respondent authorities had cancelled the promotion granted to Dijendranath Das while the order dated 20/2/2019. Accordingly, she submits that there arises no occasion for granting parity to the petitioner in the matter of promotion to the cadre of DTO with that of Dijendranath Das, inasmuch as the promotion of Dijendranath Das was already cancelled. Also, Ms. Bora, by producing an order dated, notification dated 18/5/2026, has submitted that the respondent authorities have now promoted the petitioner with effect from 14/12/2020 and the period with effect from 14/12/2020 and to 16/12/2020. That is the date on which the petitioner had joined against the promotional post, comma, would be treated as to have been spent in the promotional post, and the petitioner was held to be senior to said Asif Ahmed, who was promoted with effect from 2020. 21/11. So, I've heard the learned counsel for the parties and also perused the materials available on record. The petitioner hearing was also considered. Well, the name of the petitioner hearing was also forwarded before the Departmental Selection Committee for consideration of his case against the vacancies available in the year 2018-2019. Also, the materials brought on record, the minutes of the selection board meeting held on 6/8/2018 would go to reveal that as there was a departmental proceeding pending against the petitioner on the date of his consideration, his case was not recommended for promotion to the post of
DTO,
District Transport Officer. So, the said aspect of the matter would have required the respondent authorities to have kept the name of the petitioner in a sealed cover. However, there is no disclosure from the materials available on record that the name, that the recommendation of the selection committee in respect of the petitioner hearing was kept in a sealed cover. Be that as it may, the case of the petitioner was thereafter again considered by the selection committee, Departmental Selection Committee, in its meeting held on 3/2/2020, and it is found that the case of the petitioner was recommended for promotion to the rank of, to the post of DTO. Also, further the departmental communications, internal departmental communications placed on record by Ms. B.M.D. Bora would go to reveal that also, basing on the recommendations made in favor of the petitioner, by the Departmental Selection Committee, the petitioner was while ordered dated 21/11/2020 promoted to the post of District Transport Officer under the provisions of Regulation 4 bracketed D of the APSC of the regulations of said regulations of 1951. Also, the promotion of the petitioner was also made with a retrospective effect, that is with effect from 20 to 19, 20 to 19. That is the date when his immediate junior, Vijendranath Das, was promoted to the post of DTO. Also, thereafter, while a notification dated 12/6/2024 on the recommendation of the Assam Public Service Commission, the services, the 4D, the promotion of the petitioner made under Regulation 4D of the said regulations of 1951 was regularized. However, while regularizing the petitioner's promotion against the post of DTO, the same was so regularized with effect from his date of joining as district transport officer. Also, in other words, the retrospective effect given to the promotion of the petitioner with effect from 2019, while the order dated 21/11/2020 was ignored by the respondent authorities while regularizing his such promotion, and his promotion now was made effective from the date he had joined against the post of DTO in pursuance to the issuance of the order dated 21/11/2020. Also, it is to be noted that at this stage, the promotion effected against the post of DTO, the promotion granted to his junior, Vijendranath Das, to the post of DTO was not cancelled. The promotion effected in respect of his junior, said junior, Vijendranath Das, was cancelled by the respondent authorities only with the issuance of an order dated 5/1/2026. Accordingly, on the date the services of the petitioner was so regularized, Vijendranath Das was held to be, was continued to be considered to have been promoted to the post of DTO with effect from 20/02/2019. Also, accordingly, the petitioner ought not to have been deprived of his due of his promotion with retrospective effect, that is with effect from 20 to 2019, 19, which was so granted to him by the order dated 21/11/2020. It is to be noted that there is no order brought on record modifying the retrospective effect granted to the promotion of the petitioner to the post of DTO while the order dated 21/11/2020. Also, this court further would examine, would proceed to examine that in the event the promotion of the respondent of his junior Vijendranath Das was so cancelled with retrospective effect, on the date when he was on the date he was so recommended, a post of DTO had fallen vacant, had remained vacant. Accordingly, the petitioner being the next, being senior to him in the cadre of enforcement inspector, and from the materials brought on record, there being nothing adverse existing against the petitioner, it is the petitioner who is to be held to be now eligible for being promoted with effect from the date Vijendranath Das was so promoted. As noticed here in above, The respondent authorities have not placed on record the nature of the disciplinary proceedings instituted against the petitioner and pending when his case was so considered by the Departmental Selection Committee in its meeting held on Eight six
Lordship.
2018. However, this court finds that in the subsequent meeting, the case of the petitioner was duly considered and recommended for promotion by the Departmental Selection Committee, which can only be indicative of the fact that the departmental proceedings instituted against the petitioner came to be dropped if the above position. So accordingly, in the event of dropping of such departmental proceeding against the dropping of the departmental proceeding instituted against the petitioner, the petitioner would be entitled to have his case considered for promotion with retrospective effect upon opening of the seal cover. Considering the fact that the petitioner has already superannuated from his services with effect from
2024,
31?
2024.
31/1/2024. This court, in view of the materials available on record, more particularly the order dated 21/11/2020, promoting the petitioner to the post of District Transport Officer with effect from 20/2/2019, proceeds to direct the respondent authorities to deem that the petitioner's service such promotion was also regularized with effect from 20/2/2019. The petitioner in the present writ petition, having prayed for only grant of notional benefits for his promotion to the post of for the period with effect from 20/2/2019 till the date he had assumed charge of the post of DTO in pursuance to the order dated 21/11/2020, the respondent authorities are directed to refix the pay of the petitioner as on the date he had assumed charge of the post of DTO in pursuance to the order dated 21/11/2020 by notionally fixing his pay with effect from 20/02/2019 till the date of his such assumption of charge of the post of DTO. So thereafter, the pay and allowances of the petitioner be recomputed till the date of his superannuation occasioning on 31/1/2024, and the areas so working out be released to the petitioner. Also, the recomputation of the pay of the petitioner in the above manner would now also call for a recomputation of the pension and pensionary benefits received by the petitioner. The respondent authorities shall also make the computation in this connection and also release to the petitioner his areas of pension and pensionary benefits. Also, the said exercise be initiated and concluded within a period of 4 months from the date of receipt of a certified copy. Also, the petitioners, the areas of pay as well as of pension and pensionary benefits be also released to the petitioner within the period of 4 months permitted for completion of the exercise hearing.
Lordship,
Obliged,
this
Lordship.
adverse material brought up by my learned friend will not affect me probably.
What?
Lordship, I already observed.
You are already gone. What effect?
Lordship, they have withheld my other benefits. I have filed another writ petition.
That is
Yes, obliged, deeply obliged.
Thank you.
Obliged, Lordship. Lordship, obliged, my lord.
Yes.
Lordship,
Yes, Mr. Fukan.
Lordship, so item 5.
Yes.
Yes, sir. Lordship, this item, Lordship, previously I had argued regarding the regarding that they had done something which they could not have done. They went they host the rules.
But I find
as-
that is normally done, and you have been accommodating these people all along.
No, no, my lord, not in all. My lord, what has happened
When
is, my
was
lord,
the
if that
initial
happens,
89.
89.
89. A
Exactly.
person appointed in 92 has been accommodated by you.
my lord, that I am not sure, my lord.
Okay.
We have to bring it on
Now-
record,
now
my lord.
he is
The
not
irrigation
sure.
department is not.
You give him these copies tomorrow. Mr. Fukan, he'll give you the copies tomorrow. We are keeping this matter on Thursday.
My lord. And also, my lord, the irrigation department had produced something, or they have not given us also. I'll have to go through that also.
No, no, that is it. What they'll give you, you get your
My lord.
instructions on Thursday, we'll dispose of the matter.
My lord. And my
Uh,
lord, my submission would be, my lord, that my submission would be that, my lord,
Your
since it is
submission would
divorced
be
the
that
rules,
this is not done, but what I
That-
find is, at
that will,
least before me, there are 3-4 cases now from the records.
that will amount to negative equality, my lord.
We'll give you negative, we'll give them negative equality. If that relief demands that I should be applying, I'll apply it. You can always take your recourse. But show me, I give him those papers. He'll give you those papers. Kindly have your instructions on that.
My lord.
Mr. N. Upadhyay, Standing Council, Water Resources Department.
Irrigation.
The Irrigation Department has placed on record certain orders wherein, from which it is found that persons appointed by the Irrigation Department were subsequently promoted by the SAD department, by the Irrigation Department in the
Nazarat
Irrigation
branch.
Department, Assam Secretariat, were subsequently promoted by the Secretariat Administration Department to the higher post within the in the Secretariat. So, by making the said projection, Mr. Upadhyay would like to submit that even if the appointment of the petitioner herein was made by the Irrigation Department, he having continued, he having been paid from the budgetary support given by the SAD Department to the Irrigation Department, the petitioner is to be construed to be a member of the Assam Secretariat Service and not a member of the service of the Irrigation Department, inasmuch as there is no such service available. The said position is disputed by Mr. A. Fukan, who had appeared online. Mr. Fukan submits that he be given a copy of the documents produced by Mr. N. Upadhyay so as to facilitate him to complete his instructions in the matter. Mr. Upadhyay shall furnish to Mr. A. Fukan a set of the documents as placed before this court today. Mr. Fukan shall complete his instructions in the matter and apprise this court about shall complete his instructions and address this court on the next date of listing. Registry to list this matter again Friday ko idea. I'm giving it on Friday, so you have
Hello.
one more day.
Lordship, can it be on Monday? Because I'll have to get the whole thing, my lord,
Monday.
have to
Okay, Monday.
Monday, man.
For Friday again.
Lord,
Monday. For Friday again.
My lord.